CIV3701 Civil Law Stage 1 Part 1 Preliminary Questions C. Jurisdiction. Number 1. General Introduction. 1.1. What is jurisdiction? Jurisdiction may be defined as follows. The power or competence which a particular court has to hear and determine an issue between parties brought before it. But what does this mean in practical terms? Firstly, there are many types of courts. For example, the Small Claims Court, the Magistrates Courts, the High Court, the Supreme Court of Appeal, the Constitutional Court, the Labour Court, the Competition Appeal Court, tax courts, and the Land Claims Courts, the Electoral Court, and so on. Secondly, certain of these types of courts consist of different divisions which are scattered throughout the country. For example, at the time of writing the third edition of this book, there are main seats of divisions of the High Court in Bloemfontein, Cape Town, Grahamstown, Kimberley, Mafeking, Pietermaritzburg, and Pretoria. In some of these divisions, there are also additional seats, known as local seats, which are situated in Bisho, Durban, Johannesburg, Mthatha, Port Elizabeth, and Thohoyandou. As far as magistrates' courts are concerned, there are regional magistrates' courts for adjudication of civil disputes seated in Port Elizabeth, Bloemfontein, Johannesburg, Durban, Polokwane, Mbombela, Kimberley, Mbatu, and Cape Town. And there are district magistrates' courts seated in 2 mini-cities, towns, and villages to list here. Deciding firstly what general type of court is competent to hear your client's matter, and secondly, which particular one of the different divisions or different seats of the division of that type of court may hear the matter, is what jurisdiction is all about. It is not difficult to understand why the question of jurisdiction is so important. Until you know what type and which one of the many courts in the country has jurisdiction, you cannot take the matter any further. Let us take a slightly more detailed look at the 2 crucial jurisdictional questions. What general type, followed by which particular one? Question 1. What general type? The answer to this question will establish whether a particular matter belongs in the High Court, a Magistrates' Court, a Small Claims Court, the Labour Court, a Tax Court, the Competition Appeal Court, the Land Claims Court, or one of the many other types of courts which operate in this country. In order to answer this question, it is necessary to first answer the following 2 subsidiary questions. First, what is the monetary value of the claim? Generally speaking, the higher the value of the claim, the more senior is the court required to hear that claim. And secondly, what is the nature of the matter? By their nature, certain matters are heard by certain courts. For example, a dispute between an employer and an employee is heard usually by the Labour Court, a matter relating to the interpretation of a will by the High Court, and so on. Question number 2. Which particular one? Once it has been established which general type of court is competent to deal with a particular matter, the particular court or courts within that general type that are competent to hear the matter must be identified. This is done by linking the matter to the geographical area of jurisdiction of a particular court or courts. For example, if the defendant in a particular matter resides or works within the geographical area of jurisdiction of a particular court, or if the cause of action arose wholly in that area, that particular court will usually be entitled to hear the matter. To summarize, the value of the claim, the nature of the claim, and the area to which the claim is linked are all important aspects to be taken into account in determining jurisdiction in a particular matter. Let us now look at the different types of courts in more detail, in order to decide where our attention would be best focused in relation to the question of jurisdiction in a book such as this. 1.2. Why focus only on jurisdiction relating to the High Court and Magistrates' Courts? 1.2.1. Specialist Courts. Certain of the different types of courts mentioned above may be termed specialist courts. In other words, they deal only with certain types of matters. Magistrates' courts sitting as children's courts, district magistrates' courts sitting as maintenance courts, certain divisions of the High Court exercising admiralty jurisdiction in the determination of a maritime claim, divisions of the High Court and magistrates' courts sitting as equality courts, tax courts, the land claims courts, the electoral court, the competition appeal court, and the labor court would be examples of such courts. It is beyond the scope of this book to analyze jurisdiction in relation to each of these types of courts. If you become a specialist in one of these areas of law, you will need to acquire the knowledge required to practice in the particular court concerned, including the jurisdictional principles applicable to that court. 1.2.2 Small Claims Court. Some characteristics of the small claims court are as follows. First, generally speaking, the amount involved in matters before these courts may not exceed 15,000 rand. Secondly, only natural persons may sue, although juristic persons, for example, companies and closed corporations, may be sued. Third, the state may not be sued. Fourth, no cross-examination of witnesses is allowed. Instead, the presiding officer proceeds inquisitorially. In other words, by asking questions himself, to establish the relevant facts. Fifth, there is no appeal against the judgments of these courts. Number 6, legal representation is not allowed. In the light of the fact that no legal representation is allowed in the small claims court, and that this is a book aimed at present and future legal practitioners, we feel that the jurisdictional principles applicable to these courts are best dealt with later in the book. 1.2.3 Supreme Court of Appeal. As its name suggests, the Supreme Court of Appeal is a court of appeal. This means that you do not have to worry about the jurisdiction of this court when a matter is first handed to you. We will deal with the jurisdictional principles applicable to this court later on when we deal with appeals. 1.2.4 Constitutional Court. As in the case of the Supreme Court of Appeal, most matters which come before the Constitutional Court do so on appeal, although the Constitutional Court does not have exclusive jurisdiction in the following cases. Although the Constitutional Court does have exclusive jurisdiction in the following cases. First, disputes between organs of the state in the national or provincial sphere concerning the constitutional status, powers, or functions of those organs of state. Secondly, the constitutionality of any parliamentary or provincial bill in certain circumstances. Third, applications by members of the national parliament or one of the provincial legislatures to declare all or part of an act of parliament or the particular legislature to be unconstitutional. Fourth, the constitutionality of any amendment to the Constitution. Fifth, whether or not Parliament or the President has failed to fulfill a constitutional obligation. And lastly, certification of a provincial constitution. In addition to the above cases, the Constitutional Court may also sit as a court of first instance in matters which are sufficiently serious and urgent to require the immediate attention of the Constitutional Court. The permission of the Constitutional Court is required before this unusual procedure is adopted, and the Court is very reluctant to allow all but the most serious and urgent constitutional cases to come before it in this way. In the circumstances, it makes sense to deal with the jurisdictional principles applicable to the Constitutional Court when we deal with appeals. 1.3 Jurisdiction relating to the High Court and Magistrates' Courts. What are the main issues? All the courts referred to above may be said to be special in some way or another. At this stage of the book, we are more interested in those courts that deal with common day-to-day civil litigation. In practice, it is the magistrates' courts and the High Court that deal with the great bulk of general civil litigation in South Africa. It is for this reason that we need to focus on the jurisdiction of these courts. Let us start by rephrasing the two central jurisdictional questions in a more focused way. Question number 1. What general type? Rephrased as, must I bring this matter in the High Court or a Magistrates' Court? And question number 2, that is, which particular one, is rephrased as, in which particular division of the High Court or in which particular Magistrates' Court must I bring the matter? Let us now examine each of these more focused questions in more detail. Question 1. High Court or Magistrates' Court? We have already pointed out that the answer to this question depends on the answer to two subsidiary questions, which relate to the value of the claim and the nature of the claim. Question 1.1. What is the value of the claim? The general rule is that matters involving a claim for more than 400,000 Rand are heard in the High Court, whereas matters which involve a claim for not more than 400,000 Rand are heard in the Magistrates' Courts. In relation to matters heard in the Magistrates' Courts, those which involve claims for not more than 200,000 Rand are heard in Magistrates' Courts for districts, hereafter referred to as District Magistrates' Courts, whereas those which involve claims for more than 200,000 Rand but not more than 400,000 Rand are heard in Magistrates' Courts for regional divisions, hereafter referred to as Regional Magistrates' Courts. Generally speaking, a matter in which a magistrate's court has jurisdiction may also be heard in the division of the High Court within whose area of jurisdiction that magistrate's court is situated. In other words, that division of the High Court will exercise concurrent jurisdiction with the magistrate's court. However, you will usually proceed in the magistrate's court if you are entitled to, because it is cheaper and quicker to deal with a matter in the magistrate's court than in the High Court. It is important to remember that if you elect to proceed with a matter in a division of the High Court, despite the fact that a magistrate's court has jurisdiction to hear the matter, then even if you win the case, the High Court may decide to punish you by only granting you costs calculated on the magistrate's court's scale, which is less than costs calculated on the High Court scale. There are certain important exceptions to the general rule that matters which involve claims for more than 400,000 Rand belong in the High Court, that matters which involve claims for more than 200,000 Rand but not more than 400,000 Rand belong in the regional magistrates' courts, and that matters which involve claims for 200,000 Rand or less belongs in the district magistrates' courts. For example, in certain cases, the parties may consent to a claim that is for more than 400,000 Rand being brought in a regional magistrates' court as opposed to in the High Court, or to a claim that is more than 200,000 Rand but not more than 400,000 Rand being brought in a district magistrates' court as opposed to in a regional magistrates' court. That is by agreement. In other cases, the plaintiff in a matter may decide to abandon that portion of his claim in excess of the 400,000 Rand or 200,000 Rand limits in order to bring the matter within the jurisdiction of a regional magistrates' court or a district magistrates' court, as the case may be. In yet other cases, the plaintiff may deduct from his claim the amount of a debt which he admits he owes to the defendant, and thus bring the amount of his claim within the 400,000 Rand or 200,000 Rand limit. Question 1.2. What is the nature of the claim? The value of a claim is not the only determinant of whether it belongs in the High Court or the Magistrates' Court. The nature of the claim is also important. Certain claims involve amounts of 400,000 Rand or less, but, due to their nature, are not allowed in the Magistrates' Courts. A matter involving the interpretation of a will is a good example. Such a matter must be brought in the High Court, even if 400,000 Rand or less is at stake in the case. Another example is a claim for specific performance without the alternative of damages, which, barring certain exceptions, must always be heard in the High Court. The personal nature of such claims serves to exclude them from the jurisdiction of the magistrates' courts, even though they may involve amounts of 400,000 rand or less. Question 2. Which particular division of the High Court or Magistrates' Court must hear the matter? Once you have established the general type of court in which the matter must be heard, the High Court or Regional Magistrates' Court or District Magistrates' Court, you must decide which particular division of the High Court or which particular Magistrates' Court is competent to hear the matter. Generally speaking, you need to tie some aspect of the matter to a particular geographical area in order to establish that the court which controls that area has jurisdiction. Usually, this is done in one of two ways. First, you may be able to show that the person against whom you are instituting action either lives or works in that area. Or secondly, you may be able to show that the incident or incidents which gave rise to the claim happened in that area. 1.4. When is jurisdiction determined? Jurisdiction is determined at the time that the proceedings are instituted. Proceedings are only deemed to have been instituted once the papers initiating those proceedings have been served on the other party. For example, an action cannot be said to have been instituted until summons has been served on the defendant. As long as jurisdiction exists at the start of the proceedings, it will continue to exist until the proceedings end. Even should the particular grounds or basis upon which jurisdiction was founded fall away during the proceedings. For example, if jurisdiction is based on the fact that the defendant resides within the area of jurisdiction of the court at the start of the proceedings, jurisdiction will not be lost if, during the proceedings, the defendant happens to move and now resides outside the area of jurisdiction of the court. 1.5. Why is it important to get jurisdiction right? If you start legal proceedings against a person in a court which does not have jurisdiction, your opponent will be in a position to defeat your client's claim on the point alone without even dealing with the substance of the claim. In an action, your opponent will be entitled to raise a special plea of lack of jurisdiction, which effectively will bring the matter to an end. In an application, the court will not hear the matter if it is not satisfied that it has jurisdiction based on the facts stated in the papers. It is important to keep in mind that if you are acting for the applicant or plaintiff in a matter, it is up to you to make sure that you set out the grounds upon which jurisdiction is based. C. Jurisdiction number 2. Magistrates' Court's jurisdiction. 2.1. General overview. The magistrates' courts are creatures of statute, which means that they have no jurisdiction apart from that which is conferred upon them by statute. The relevant sections of the Magistrates' Courts Act dealing with jurisdiction are subsection 26 to 50. Let us examine the manner in which certain of these sections relate to the two fundamental questions discussed earlier, which arise when deciding upon jurisdiction. Question 1. High Court or Magistrates' Court? The answer to this question depends upon the answer to two subsidiary questions. What is the value of the claim and what is the nature of the claim? Section 29 deals, broadly speaking, with the general rule that claims for 200,000 rand or less may be heard in a district magistrates' courts, whereas claims for more than 200,000 rand but not more than 400,000 rand may be heard in the regional magistrates' courts. The section is your first stop in deciding whether a matter belongs in the magistrates' courts or the High Court. Sections 38, 39, and 45 deals with an important set of exceptions to the general rule referred to above. These sections deal respectively with abandonment, deduction of an admitted debt, and consent. These are different ways in which claims for more than 400,000 rand, which would normally belong in the High Court, may be brought within the jurisdiction of the Regional Magistrates' Court, and in which claims for more than 200,000 rand, but not more than 400,000 rand, which would normally belong in the Regional Magistrates' Courts, may be brought within the jurisdiction of the district magistrates' courts. Question 1.2. What is the nature of the claim? Section 46 is your second important stop in deciding whether a matter belongs in the magistrates' court or the High Court. This section details a number of claims which, because of their nature, may not be brought in the magistrates' courts. In other words, the section lists certain claims which, although they may be for 400,000 Rand or less, must nevertheless be heard in the High Court. Question 2. Which particular magistrates' court? Section 28 deals with the question which arises once you know that a matter belongs within the magistrates' courts, namely, in which particular magistrates' court or courts may this matter be heard. The section sets out the manner in which a particular matter may be tied to the area of jurisdiction of a particular magistrates' court or courts. With the general mind map in place, let us now deal with each section in turn. 2.2. The value of the claim. Section 29. 2.2.1. The general rule. As a general rule, if the claim or the value of the matter in dispute is over 400,000 Rand, the matter falls within the jurisdiction of the High Court. If the claim or value of the matter in dispute is over 200,000 Rand, but not over 400,000 Rand, the matter falls within the jurisdiction of the regional magistrates' courts. If the claim or the value of the matter in dispute is 200,000 Rand or less, the matter falls within the jurisdiction of the district magistrates' courts. Let us examine the provisions of Section 29 more closely. 2.2.1 A. Section 29, subsection 1a. Delivery or transfer of property. District magistrates' courts possess jurisdiction in respect of actions in which is claimed the delivery or transfer of any property, movable or immovable, not exceeding 200,000 Rand in value. Regional magistrates' courts possess jurisdiction in respect of actions in which is claimed the delivery or transfer of any property, movable or immovable, exceeding 200,000 Rand but not exceeding 400,000 Rand in value. Value means the actual market value of the property. 2.2.1b. Section 29, subsection 1b. Ejectment. District magistrates' courts possess jurisdiction in respect of actions of ejectment against the occupier of any premises or land within the relevant district, provided that where the right of occupation of any such premises or land is in dispute between the parties, such right does not exceed the amount of 200,000 Rand in clear value to the occupier. Regional magistrates' courts possess jurisdiction in respect of actions of ejectment against the occupier of any premises or land within the relevant regional division, provided that where the right of occupation of any such premises or land is in dispute between the parties, such right exceeds the amount of 200,000 Rand, but does not exceed the amount of 400,000 Rand in clear value to the occupier. But satisfying the court that there is a bona fide dispute as his right of occupation and that the clear value to him of this disputed right exceeds 200,000 Rand or exceeds 400,000 Rand, an occupier is able to oust the jurisdiction of the district magistrates' courts or the regional magistrates' courts, as the case may be. The subsection specifically talks about the clear value of the right of occupation to the occupier. It is submitted that by clear value is meant the value over and above the rent payable. In cases of ejectment from business premises, an additional method of calculation is available, which may be used when suitable alternative premises are not available to the occupier of those business premises. For example, the premises in question may be specialized factory premises which are unique in the general area. If the occupier is threatened with ejectment from the factory, he may claim that he is unable to find suitable alternative premises to carry on his business. In such a matter, you would calculate the amount of the profit which the occupier reasonably expects to make over the period for which he claims the right to occupy the disputed premises. In conclusion, note that our courts have not approved a generally applicable formula or test which can be used to determine the value of the right of occupation. Rather, a conspectus of the whole transaction must be taken, including not only objective information but also matters which are personal to the occupier. It is not possible in a book such as this to delve more deeply into this complex area of law. When dealing with matters involving the value of the right of occupation in practice, practitioners are advised to research the many cases dealing with this point thoroughly. 2.2.1c, Section 29, subsection 1c, Right of way. Magistrates' courts possess jurisdiction in respect of actions for the determination of a right of way, notwithstanding the provisions of Section 46, that is, matters beyond the jurisdiction of the magistrates' court. The value of the right of way is not relevant to jurisdiction. The magistrates' courts have jurisdiction not only to confirm an existing right of way, but to create a via necessitatis, that is, a necessary access route. 2.2.1 D. Section 29, subsection 1d, a liquid document or mortgage bond. District magistrates' courts possess jurisdiction in respect of actions on or arising out of a liquid document or a mortgage bond where the claim does not exceed 200,000 Rand. Regional magistrates' courts possess jurisdiction in respect of actions on or arising out of a liquid document or a mortgage bond where the claim exceeds 200,000 Rand but does not exceed 400,000 Rand. Broken down in formal terms, a liquid document is one that indicates, without the need to resort to extrinsic evidence, first, an acknowledgement of indebtedness, secondly, in an ascertainment amount of money, and third, the payment of which is due to the creditor. An example of a liquid document is a piece of paper on which someone else has written that he owes a specific amount of money to someone else. Liquid documents include checks, acknowledgements of debt, mortgage bonds, which are really just a particular kind of acknowledgement of debt, and promissory notes, IOUs, Usually, if a document shows that payment is conditional, it will not qualify as a liquid document. A simple condition will not, however, destroy the liquidity of a document. A simple condition is unlikely to give rise to a dispute, or if disputed, is easily proved. For example, an acknowledgement of debt which contains a condition that notice must be given to the debtor before payment is claimed still qualifies as a liquid document. 2.2.1 E. Section 29(1)(e), Credit Agreements. Magistrates' courts possess jurisdiction in respect of actions on or arising out of any credit agreement as defined in Section 1 of the National Credit Act 34 of 2005. Section 4 of this Act defines a credit agreement as an agreement that meets all the criteria set out in Section 8 of the Act. Section 29, subsection 1e of the Magistrates' Courts Act, read with Section 172, subsection 2 of the National Credit Act, appears to give the magistrates' courts unlimited monetary jurisdiction in relation to matters falling under the National Credit Act. In terms of Government Notice 216 in Government Gazette 37477 of 27 March 2014, however, the Minister of Justice and Correctional Services purports to limit the jurisdiction of the regional magistrates' courts under Section 29, subsection 1e to amounts exceeding 200,000 Rand, but not exceeding 400,000 Rand. However, Section 29 subsection 1e does not appear to give the minister the power to make such determination, and it is unclear at the time of writing the third edition of this book whether or not the monetary jurisdiction of the regional magistrates' courts in respect of the actions referred to in the said sections is in fact limited. In our view, the better approach is that the monetary jurisdiction of the regional magistrates' courts is not limited in this way. 2.2.1 Section 29, subsection 1f Matrimonial Property Act. District magistrates' courts possess jurisdiction in respect of actions in terms of Section 16, subsection 1 of the Matrimonial Property Act, explained in the next paragraph, where the claim or value of the property in dispute does not exceed 200,000 rand. Regional magistrates' courts possess jurisdiction in respect of claims in terms of Section 16, subsection 1 of the Matrimonial Property Act, where the claim or value of the property in dispute exceeds 200,000 rand but does not exceed 400,000 rand. Sections 15, subsection 2 and 3 of the Matrimonial Property Act require a spouse who is married in community of property to obtain the consent of the other spouse if he or she wishes to deal with the community property in certain ways. Section 17 of that Act requires such a spouse to obtain the consent of the other spouse before instituting or defending legal proceedings, except in certain cases. Sometimes the consent required in terms of the above-mentioned sections of the Act is unreasonably withheld by the other spouse or cannot be obtained for some other reason. Section 16, subsection 1 of the Matrimonial Property Act allows the spouse who is being frustrated by the lack of consent to apply to court for the consent needed. In such cases, if the claim or value of the property in dispute is more than 400,000 rand, then proceedings will have to be brought in the High Court. If the claim or value of the property in dispute is more than 200,000 rand but not more than 400,000 rand, then proceedings will have to be brought in a regional magistrates' court. If the claim or value of the property in dispute is 200,000 rand or less, then proceedings will have to be brought in a district magistrates' court. 2.2.1g Section 29, subsection 1 FA Closed Corporations Act. Magistrates' courts possess jurisdiction in respect of actions including an application for liquidation in terms of the Closed Corporations Act 69 of 1984. All matters involving liquidation and insolvency are generally restricted to the High Court. The Magistrates' Court possess jurisdiction to wind up closed corporations irrespective of the amounts involved. This fits in with the idea that closed corporations are tailored to meet the needs of smaller business entities. The High Court does not, however, possess concurrent jurisdiction. 2.2.1h Section 29, subsection 1g All other actions. District magistrates' courts possess jurisdiction in respect of actions other than those discussed above, where the claim or the value of the matter in dispute does not exceed 200,000 rand. Regional magistrates' courts possess jurisdiction in respect of actions other than those discussed above, where the claim or the value of the matter in dispute exceeds 200,000 rand but does not exceed 400,000 rand. Section 29, subsection 1g is a catch-all, where a plaintiff claims delivery of property, alternatively damages, then if either the value of the property or the damages exceed 400,000 rand, the claims will have to be brought in the High Court. Similarly, in the case of an interdict, if the value of the subject matter in dispute exceeds 400,000 rand, such interdict will have to be sought in the High Court. Matters in which the values in question exceed 200,000 rand but do not exceed 400,000 rand belong in the regional magistrates' courts, whereas matters in which the values in question do not exceed 200,000 rand belong in the district magistrates' courts. As in the case of all the other subsections of Section 29, subsection 1 discussed above, This subsection is subject to the provisions of Section 46, which is discussed below. For example, a magistrate's court may not decide on the validity of a will, even if the value of the deceased estate is not more than 400,000 rand. 2.2.1 I. Section 29, subsection 1b. Divorce and related matters. Regional Magistrates' Courts. In terms of Section 29, subsection 1ba of the Magistrates' Courts Act, the Regional Magistrates' Courts are granted jurisdiction to hear and determine suits relating to the nullity of a marriage or a civil union, and relating to divorce between persons, and to decide upon any question arising therefrom, and to hear any matter and grant any order provided for in terms of the Recognition of Customary Marriages Act. Section 29, subsection 1bb makes it clear that a regional magistrate's court hearing a matter referred to above shall have the same jurisdiction as any division of the High Court in relation to such a matter. Note therefore that what we have called the general rule, which stipulates a 400,000 rand limit for most types of claims which may be dealt with by the regional magistrates' courts, and a 200,000 rand limit for the district magistrates' courts, does not apply to the types of claims referred to in Section 29, subsection 1ba, discussed above. Section 29, subsection 1bc, provides that the presiding officer of a regional magistrates' court, hearing a matter referred to above, may, in his or her discretion, summon to his or her assistance 2 persons to sit and act as assessors in an advisory capacity on questions of fact. Practitioners are referred to the practice directives in respect of divorce matters, which appears in paragraph 6 of the Civil Practice Directives for the regional courts in South Africa. Finally, practitioners should note that the Magistrates' Courts rules have been amended, purportedly with effect from the 1st of December 2014, to make provision in Rules 70 to 87 for the voluntary submission of civil disputes to mediation in selected courts. 2.2.2 How to calculate the 200,000 rand and 400,000 rand limits. 2.2.2 A. Splitting of single claims not allowed, as per Section 40. In terms of Section 40, a substantive claim exceeding the jurisdiction of the particular magistrate's court concerned may not be split with the objective of recovering the same in more than one action, if the parties to all such actions would be the same, and the point at issue in all such actions would also be the same. A substantive claim in the context of Section 40 is a claim arising out of a single cause of action. In other words, you cannot get around the monetary limits set for jurisdiction in the magistrates' courts by artificially dividing up a claim arising out of a single cause of action. For example, you cannot take a single claim for 600,000 rand and split it up into 2 separate claims for 300,000 rand each, in order to bring the matter within the jurisdictional limits of the regional magistrates' courts. This rule against the splitting of claims may give rise to certain difficulties in practice. For example, assume that you are renting a factory to a businessman at a rental of 50,000 rand per month. He has not paid the rent for 6 months, and this owes you a total amount of 300,000 rand. Although the total amount owing is over 200,000 rand, this matter will nevertheless fall within the jurisdiction of the district magistrates' court, because a separate claim arises each time the businessman does not pay his rent for a particular month. Each month's rent constitutes a separate cause of action, because each payment is due on a separate date. In each instance, the cause of action will arise due to the breach of the lease agreement entered into between yourself and the businessman. But remember that there is a separate breach of the agreement giving rise to a separate cause of action each time a month's rent is not paid. In short, you will be entitled to bring 6 separate claims for 50,000 rand each. Each claim falls comfortably within the monetary limit set for the jurisdiction of the district magistrates' courts. Note that in terms of section 43, subsection 1, discussed below, you will be entitled to include all these claims in one summons. Although grouped in one summons, they will remain separate claims. 2.2.2 B. Combining separate claims is allowed, as per section 43, subsection 1. In terms of section 43, subsection 1, if two or more claims, each based upon a different cause of action, are combined in one summons, the court shall have the same jurisdiction to decide each such claim as it would have had if each claim had formed the sole subject of a separate action. In other words, if you have a number of separate claims, each of which is based on a separate cause of action, these claims may be combined in one summons, even though the total amount claimed in the summons may not amount to more than 200,000 Rand or 400,000 Rand. The district's magistrates' courts or the regional magistrates' courts, as the case may be, may still hear such a matter, provided that the amount of each individual separate claim is not more than 200,000 Rand or 400,000 Rand, as the case may be. 2.2.2c. Only the amount in issue is taken into account, as per section 37, subsection 1 and 2. In terms of section 37, subsection 1, in actions wherein the sum is claimed, being within the jurisdiction, is the balance of an account, the court may inquire into and take evidence, if necessary, upon the whole account, even though such account contains items and transactions exceeding the amount of the jurisdiction. Assume, for example, that you wish to institute an action against a debtor for 200,000 Rand. Your original claim against the debtor was 250,000 Rand, but she has paid back 50,000 Rand. The district magistrates' courts may hear this matter, since the claim itself does not amount to more than 200,000 Rand. The particular magistrates' courts dealing with the matter may hear evidence in respect of the entire amount that was outstanding originally. In terms of section 37, subsection 2, where the amount claimed or other relief sought is within the jurisdiction of a particular magistrates' court, such jurisdiction shall not be ousted merely because it is necessary for the court, in order to arrive at a decision, to give a finding upon a matter beyond the jurisdiction. 2.2.2 D. Interests and costs not taken into account. Section 37, subsection 3. In terms of section 37, subsection 3, when considering whether or not a claim is within the jurisdiction of the magistrates' courts, no prayer for interests on the principal sum claimed, or for costs, or for general or alternative relief shall be taken into account. Assume, for example, that your total claim is for 270,000 Rand. You may be inclined to think that this claim falls outside the jurisdiction of the district magistrates' courts. Assume further, however, that the amount of 270,000 Rand is made up as follows. 200,000 Rand is the principal sum claimed. 45,000 Rand is the interest, and 25,000 Rand is the costs. In this case, your claim falls within the jurisdiction of the district magistrates' courts, because your claims for interest and costs are not taken into account when assessing the amount of the claim for jurisdictional purposes. Apart from providing that prayers for interests and costs are not taken into account for jurisdictional purposes, section 37, subsection 3 also provides that any prayer for general or alternative relief should be ignored for jurisdictional purposes. Note that attorneys often add a prayer for further and or alternative relief to their other prayers to provide them with a fallback position in case they have framed one of their prayers incorrectly or left out a prayer by mistake. 2.2.3 Exceptions to the general rule. Listed below are 3 ways to bring a matter involving a claim for over 200,000 Rand or for over 400,000 Rand within the jurisdiction of the district magistrates' courts or the regional magistrates' courts, as the case may be. First, consent. Second, abandonment. Or third, deduction of an admitted debt. 2.2.3a consent, as per Section 45. One possible way in which a claim for over 200,000 Rand or for over 400,000 Rand may be brought within the jurisdiction of the District Magistrates Courts or the Regional Magistrates Courts, as the case may be, is for the parties to consent to such jurisdiction. In terms of Section 45, subsection 1, subject to the provisions of subsection 46, the Magistrates Courts shall have jurisdiction to determine any action or proceeding otherwise beyond their jurisdiction, if the parties consent in writing thereto. This is provided that no court other than a court having jurisdiction under Section 28, except where such consent is given specifically with reference to particular proceedings already instituted or about to be instituted in such court, shall have jurisdiction in any such matter. The first point to note is that the parties must consent in writing. This written consent need not, however, take the form of an express agreement which is signed by the parties. All that is required is some sort of writing or writings which amount to proof that each of the parties has consented to jurisdiction. The second point to note is that there are certain limitations. 2.2.3 A. Number 1. First limitation. By their nature, certain claims must be heard in the High Court. These claims are set out in Section 46. Parties cannot seek to override the provisions of Section 46 by means of a written consent in terms of Section 45. For example, the parties to a dispute in relation to a will are not entitled to consent to the jurisdiction of the magistrates' courts. Section 46 provides that such a matter must be heard in the High Court. Matters excluded from the jurisdiction of the magistrates' courts by Section 46 remain excluded, no matter what the parties agree to. Section 90, subsection 2K6BB of the National Credit Act contains a provision which has a similar effect, albeit only in respect of credit agreements to which that Act applies. In terms of this section, a provision of a credit agreement which purports on behalf of the debtor to consent to the jurisdiction of any court seated outside the area of jurisdiction of a court having concurrent jurisdiction and in which the consumer resides or works or where the goods in question are ordinarily kept is unlawful. Parties also cannot seek to override the provisions of Section 90 and 91 of the Act by means of a written consent in terms of Section 45. 2.2.3a number 2. Second limitation. Section 45 allows parties to consent to the jurisdiction of the district magistrates' courts or the regional magistrates' courts in general, that is, to bring the matter within the jurisdiction of either the district magistrates' courts or the regional magistrates' courts in general, even though the value of the claim may be over 200,000 Rand or over 400,000 Rand, as the case may be. It does not, however, allow them to consent to the jurisdiction of a particular magistrate's court unless that particular magistrate's court has jurisdiction over the person of the defendant in terms of Section 28 of the Magistrates' Courts Act. However, if proceedings have already been instituted or are about to be instituted, the parties are entitled to consent to the jurisdiction of any particular magistrate's court. Even though a particular court does not exercise jurisdiction over the defendant in terms of Section 28 of the Magistrates' Courts Act, in simple terms, consent in terms of Section 45 may allow you to circumvent the jurisdictional provisions of Section 29, that is, to ignore the general rule stipulating limits of 200,000 Rand and 400,000 Rand in respect of most claims to be brought in district magistrates' courts and regional magistrates' courts, respectively. However, consent will not allow you to circumvent the jurisdictional provisions of Section 28, that is, to ignore the need to link your claim to a particular magistrate's court by showing that that particular court has jurisdiction over the person of the defendant, unless proceedings have been instituted or are about to be instituted in that particular magistrate's court. Let us examine a situation which often arises in practice. Assume you are drafting a contract involving amounts of over 200,000 Rand for a client. In the event that the other party breaches the contract, you wish to afford your client the right to sue that party in the district magistrate's court since it is quicker and cheaper. Your client asks you to insert a clause to the effect that in the event of breach, the parties consent to the jurisdiction of the magistrate's court for the District of Durban. At this stage, the parties are not contemplating immediate legal action against each other. A breach of the contract may occur only at some time in the distant future, if at all. At the time the contract is being drafted, it is difficult for the parties to know whether the magistrate's court for the District of Durban will, at the time the contract is breached, be in a position to exercise jurisdiction in terms of Section 28 of the Magistrates Courts Act over the party responsible for the breach. Therefore, you should advise your client that it is preferable to insert a clause in which the parties consent to the jurisdiction of the District Magistrates Court in general, avoiding any reference to the Magistrates Court for the District of Durban. So, in Van Heerden versus Moore, for example, the appellant sued the defendant in the Magistrates Court in Bloemfontein. In those days, there was no distinction between magistrates' courts for districts and magistrates' courts for regional divisions, for a certain sum on a promissory note, or an IOU. The defendant did not reside within the area of jurisdiction of the Bloemfontein Magistrates Court, but the appellant argued that her consent to that jurisdiction was evidenced by a section at the foot of the promissory note in which the defendant had agreed to the jurisdiction of the Bloemfontein Magistrates Court in terms of Section 45, subsection 1. According to the court, in this case, the consent in the present case purports to have been given in terms of Section 45, subsection 1 of the Act. The proviso to the above subsection, which prohibits persons from consenting to the jurisdiction of a particular magistrate's court, unless that particular magistrate's court has jurisdiction over the person of the defendant in terms of Section 28 of the Magistrates Courts Act, is clearly of no assistance to the appellant because the consent relied by him was not given when the present proceedings had already been instituted in the Bloemfontein Magistrates Court or were about to be instituted in that court, but were given at the time the defendant signed the promissory note. Finally, note that in terms of Section 45, subsection 2, any provision in a contract whereby a person undertakes that when proceedings have been or are about to be instituted, he will give such consent to jurisdiction as is contemplated in the proviso to Section 45, subsection 1, shall be null and void. In other words, the parties cannot avoid the second limitation discussed above by agreeing to agree to the jurisdiction of a particular magistrate's court if and when a dispute arises between them. Any such provision in a contract will be null and void. 2.2.3b Abandonment, as per Section 38. A second possible way in which a claim for over 200,000 Rand or for over 400,000 Rand may be brought within the jurisdiction of the district magistrates' courts or the regional magistrates' courts, as the case may be, is for the plaintiff to abandon that part of his claim which is over 200,000 Rand or over 400,000 Rand, as the case may be. In terms of Section 38, subsection 1, in order to bring a claim within the jurisdiction of the magistrates' court, a plaintiff may, in his summons or at any time thereafter, explicitly abandon part of such a claim. As to the manner in which the abandonment is effected, assume that your client's claim is for 205,000 Rand and he wishes to abandon 5,000 Rand. You may include the following paragraph in your client's particulars of claim. The defendant is indebted to the plaintiff in the amount of 205,000 Rand. in order to bring his claim within the jurisdiction of the District Magistrates Courts in terms of Section 38, subsection 1 of the Magistrates Courts Act 32 of 1944, the plaintiff hereby abounds the amount of 5,000 rand of his claim. In terms of Section 38(2), subsection 2, if any part of a claim is abandoned in terms of Section 38, subsection 1, it is thereby finally extinguished, provided that if the claim be upheld or part only, the abandonment shall be deemed first to take effect upon that part of the claim which is not upheld. Let us examine two examples to illustrate what this means. Example number 1. Someone drives through a red traffic light and crashes into your car. You have a claim against that person for damages to your motor vehicle in the amount of 210,000 rand. Those damages are made up of 190,000 rand damages to the body of the vehicle and 20,000 rand damages to the air conditioning system of the vehicle. It is still a single claim for damages in the amount of 210,000 rand, since there is only one cause of action, that is, the delict committed against you when the other party crashed into your car. For the sake of convenience, you decide to abandon 10,000 rand of your total claim in order to bring the claim within the jurisdiction of the District Magistrates Courts. For some reason or other, during the trial in the District Magistrates Court, you are unable to prove the damages to the air conditioning system of your car. You are able, however, to prove the full damages to the body of the vehicle. Were it not for the proviso to Section 38, subsection 2, it might be possible to reason as follows. You have abandoned 10,000 rand of your claim. You have been unable to prove 20,000 rand damages to the air conditioning system of your car. Therefore, you are only entitled to 210,000 rand total claim minus 10,000 rand abandoned minus 20,000 rand unproved damages, which is 180,000 rand. The proviso, however, makes it clear that the abandonment shall be deemed first to take effect upon that part of the claim which is not upheld. Therefore, the abandonment of 10,000 rand must be set off against that part of your claim which is not upheld, and not against that part of your claim which you did actually prove. In other words, the 10,000 rand which you abandoned is set off against 20,000 rand which you failed to prove, and not against the 190,000 rand which you did prove. If you find this too difficult to digest, think of it as follows. Damages must be calculated positively. In other words, you get what you managed to prove up to a maximum of 200,000 rand. In the case of claims where an amount has been abandoned to bring the claim within the jurisdictional limit of the District Magistrates Courts, or up to a maximum of 400,000 rand. In the case of claims where an amount has been abandoned to bring the claim within the jurisdictional limit of the Regional Magistrates Courts. In the example above, you managed to prove 190,000 rand damages to your vehicle. So this is the amount which you are entitled. Example 2. In some cases, the amount of your claim that is not upheld will be less than the amount of your claim which you have abandoned. Taking the above example, but using different figures, assume that you are able to prove damage to the body of your car in the amount of 205,000 rand, but are not able to prove damage to the air conditioning system in the amount of 5,000 rand. After subtracting the amount of 5,000 rand which you could not prove from your full claim, in the amount of 210,000 rand, you are left with 205,000 rand. Remember, however, that you may not claim more than 200,000 rand in the District Magistrates Court, because you chose to abandon 10,000 rand to bring the matter within the jurisdiction of the District Magistrates Court. You will have to be satisfied with a claim of 200,000 rand. Example 3. The reasoning set out in the first two examples also apply in cases where the court awards you a percentage of your claim. Assume your claim is 210,000 Rand and you abandon 10,000 Rand. At the end of the case, the court decides that you are entitled to 50% of your claim. You will be entitled to 50% of 210,000 Rand, which is 105,000 Rand. 2.2.3 C. Deduction of an admitted debt. Section 39. A third possible way in which a claim for more than 200,000 Rand may be brought within the jurisdiction of the District Magistrates Courts, or a claim for more than 400,000 Rand may be brought within the jurisdiction of the Regional Magistrates Courts, is for the plaintiff to deduct from her claim a debt which she owes to the defendant. In terms of Section 39, in order to bring a claim within the jurisdiction of the Magistrates Courts, a plaintiff may, in her summons or at any time after the issue thereof, deduct from her claim, whether liquidated or unliquidated, any amount admitted by her to be due by herself to the defendant. Assume, for example, that X crashes into Y's motor vehicle and causes damages in the amount of 220,000 Rand. Y, however, owes X an amount of 25,000 Rand for services rendered by X to Y. If Y wishes to institute action against X, he is entitled to deduct the amount of the debt he admits he owes, that is, the 25,000 Rand, from the amount of his claim against X, that is, 220,000 Rand, in order to bring the matter within the jurisdiction of the District Magistrates Courts, that is, 220,000 Rand minus 25,000 Rand, which equals 195,000 Rand, which is within the jurisdictional limit of the District Magistrates Courts. If your claim is over the limit for either the District Magistrates Courts or the Regional Magistrates Courts, and you know that you owe the defendant a debt, it is always wise to deduct the amount you owe the defendant in terms of Section 39, rather than abandoning part of your claim in terms of Section 38, in order to bring the matter within the jurisdiction of the District Magistrates Courts or the Regional Magistrates Courts, as the case may be. If you do not deduct the admitted debt but abandon it, the defendant may simply institute a counterclaim for the amount of the debt, and you may end up losing money because of your abandonment of part of your claim. Let us take two scenarios. In scenario 1, you use Section 38 to bring your claim within the jurisdiction of the District Magistrates Courts, even though you are aware that you owe the defendant money. In scenario 2, you use Section 39 instead. Look at what happens. Scenario 1. Your claim is 210,000 Rand, and you abandon 10,000 Rand to bring the matter within the jurisdiction of the District Magistrates Court, even though you know that you owe the defendant 20,000 Rand. You foolishly hope that he will forget about this debt. The defendant then counterclaims for 20,000 Rand. Both you and the defendant prove the full amounts owed. That is, that you prove 210,000 Rand and he proves 20,000 Rand. Because you have abandoned 10,000 Rand, this amount is finally extinguished, and so you are entitled only to 200,000 Rand. However, the defendant was also successful in his counterclaim and is entitled to 20,000 Rand. In effect, you will end up receiving only 180,000 Rand. That is the 200,000 Rand minus the 20,000 Rand, which only gives you 180,000 Rand. Scenario 2. Your claim is 210,000 Rand. You know that you owe the defendant 20,000 Rand and wisely decide to deduct this amount from your claim. In order to bring the claim within the jurisdiction of the District Magistrates Courts in terms of Section 39, you prove the full amount owed to you by the defendant, and the court awards you your full claim less the amount of the admitted debt. That is 210,000 Rand minus the 20,000 Rand, which gives you 190,000 Rand in your pocket. With scenario 1, you receive 180,000 Rand. With scenario 2, you receive 190,000 Rand. Which would you rather have? The only potential drawback is that having admitted the defendant's claim, you have to pay it, even if you cannot prove your own claim. Once you admit this claim, the defendant is no longer under an obligation to prove it. Before adopting the procedure set out in Section 39, you should evaluate the defendant's claim against you. You may decide that the procedure should not be followed if it is clear that the defendant has a weak claim which is difficult to prove. 2.3. The nature of the claim. Section 46. Section 46 of the Magistrates Courts Act is very important because it sets out certain types of claims which, by their nature, may not be brought in the magistrates' courts. Such claims must be brought in the High Court, even though they are for 400,000 Rand or under. If a claim is one of those listed in Section 46, it is beyond the jurisdiction of the magistrates' courts. Even if the parties wish to consent to the jurisdiction of the magistrates' courts, they are not entitled to do so. The matter must be heard in the High Court. If a matter which falls under Section 46 is brought before a magistrates' court, that court must miro montu decline jurisdiction even though the issue has not been raised in the defendant's plea. In simple terms, Section 46 may be said to involve two types of claims: status claims and specific performance claims. 2.3.1 Status claims. You will notice that certain of the claims listed in Section 46 affect the personal status of people in some way or another. Such claims are sensitive in nature, and it makes sense that they received the special consideration which the High Court is able to afford them. Note that this does not include divorce matters, which some regional magistrates' courts do have the competence to entertain. 2.3.1a Wills, as per Section 46, subsection 2a. In terms of Section 46, subsection 2a, the magistrates' courts shall have no jurisdiction in matters in which the validity or interpretation of a will or other testamentary document is in question. It is clear, therefore, that matters relating to the validity or interpretation of a will or other testamentary document must be heard in the High Court. 2.3.1b Mental capacity, as per Section 46, subsection 2b. In terms of Section 46, subsection 2b, the magistrates' courts shall have no jurisdiction in matters in which the status of a person in respect of mental capacity is sought to be affected. In certain cases, it is necessary to apply to court to declare a person to be of unsound mind and incapable of managing his own affairs. The reasons for the application is to enable the court to appoint a curator bonus to take over the running of that person's affairs. Such matters must be heard in the High Court. 2.3.1c Perpetual silence, as per Section 46, subsection 2d. In terms of Section 46, subsection 2d, the magistrates' courts shall have no jurisdiction in matters in which is sought a decree of perpetual silence. In the case of Garber N.O. versus Witwatersrand Jewish Aged Home, Vermooten described the circumstances under which one will be entitled to seek a decree of perpetual silence as follows. As a general rule, a plaintiff may choose his own time within which to institute actions against a defendant. Certain exceptions to this rule are recognized both by the Roman Dutch writers and by our courts. Thus, when a prospective plaintiff is publicly threatened the defendant that he will bring an action against him, the threatened defendant is entitled to come to court to ask the prospective plaintiff be put to terms in regard to the bringing of his actions and to claim an order for perpetual silence against the latter in respect of the matter in question should he fail to institute his action within the time stipulated by the court. Clearly, any such application must be heard in the High Court. 2.3.2 Claims for specific performance. In terms of Section 46, subsection 2c, the magistrates' courts shall have no jurisdiction in matters in which is sought specific performance without an alternative of payment of damages, except in, first, the rendering of an account in respect of which the claim does not exceed 200,000 rand. Secondly, the delivery or transfer of property, movable or immovable, not exceeding 200,000 rand in value. And third, the delivery or transfer of property, movable or immovable, exceeding 200,000 rand in value, where the consent of the parties has been obtained in terms of Section 45. 2.3.2 A. General Rule. The general rule, subject to the exceptions that will be dealt with below, is that the magistrates' courts have no jurisdiction in matters where the plaintiff claims specific performance without an alternative of payment of damages. For example, I agree to paint your house and you agree to pay me 25,000 rand for my labor. You pay me the 25,000 rand, but I refuse to paint your house. I offer to return the 25,000 rand to you, but you insist that I must carry out the painting job as agreed. Your claim amounts to a claim for specific performance without the alternative of payment of damages. There is some debate as to whether specific performance in the context of Section 46 is restricted to those instances in which the plaintiff is seeking performance in terms of a contract, or whether it refers to all cases in which the plaintiff is seeking some kind of performance. It seems settled now that the former is the correct interpretation. If this is correct, claims for specific performance without an alternative for payment of damages which do not arise out of a contract are not excluded from the jurisdiction of the magistrates' courts in terms of Section 46, subsection 2c. In practice, however, most claims for specific performance will be for performance in terms of a contract. For those who may be technically minded, note that when we speak of specific performance in this context, we mean performance of obligations in terms of a contract, other than the obligation to pay money, that is, performance ad factum prestandum as opposed to performance ad pecuniam solvendam. To take the example we have just used, if you ask the court to order me to paint the house, that would be asking for an order of specific performance in the context of Section 46. But if I ask the court to order you to pay me the 25,000 rand in terms of the contract, that would not be asking for an order of specific performance in the context of Section 46. 2.3.2b. Exceptions to the general rule. There are 3 exceptions to the general rule that claims for specific performance without an alternative of payment of damages are beyond the jurisdiction of the magistrates' courts. 2.3.2b. 1. Exception number 1. Rendering of an account. If the claim for specific performance without an alternative of payment of damages is for the rendering of an account, in respect of which the claim does not exceed 200,000 rand, the matter may be heard in the magistrates' court. A duty to account may arise in different circumstances. For example, this duty may form part of a contract between the parties, or it may arise out of the fact that the parties stand in a fiduciary relationship to one another, as in the case of partners in a partnership. Note, however, that a duty to account does not arise simply because a debtor-creditor relationship exists between the parties. Let us take the example of a partnership. Upon the dissolution of a partnership, there is a duty on the partners to account to each other for their respective management or handling of the partnership assets. Even if the partnership is not dissolved, there may be a duty on the managing partner to account to his co-partners at regular intervals. Assume that you are in partnership with another person. In terms of the partnership agreement, you have agreed to split the profits of the partnership 50-50. You believe the profits of the partnership to be in the region of 400,000 Rand, but your partner tells you that the profits only amount to 50,000 Rand. Your partner manages the partnership business and is responsible for keeping a record of all the income and expenses of the business. In this case, you may institute a claim against your partner in the Magistrates Court for: first, the rendering of an account; secondly, debate of the account rendered; and lastly, payment of the amount found due by the defendant, up to a maximum of 200,000 Rand. 2.3.2b2. Exception number 2. Delivery or transfer of property valued at or under 200,000 Rand. If the claim for specific performance without an alternative for payment of damages is for the delivery or transfer of property, movable or immovable, which does not exceed 200,000 Rand, the matter may be heard in the Magistrates' Courts. This exception covers many claims which arise in practice. For example, you agree to sell me your car for 150,000 Rand. I pay you the 150,000 Rand, but you refuse to deliver the car to me. You offered to pay the 150,000 Rand back to me, but I insist that I want the car as we agreed. This is a claim for specific performance without an alternative of payment of damages. However, since I am asking for the delivery of movable property, the matter is not beyond the jurisdiction of the Magistrates' Courts. 2.3.2b3. Exception 3. Delivery or transfer of property valued at over 200,000 Rand. If the claim for specific performance without an alternative of payment of damages is for the delivery of transfer of property, movable or immovable, which exceeds 200,000 Rand, the matter may be heard in the Magistrates' Courts, provided that the parties consent to the jurisdiction of the Magistrates' Courts in terms of Section 45. 2.3.2 C. Summary. To sum up, the following methods may be used to decide whether or not a claim for specific performance is excluded from the jurisdiction of the Magistrates' Courts in terms of Section 46, subsection 2c. First, does the claim for specific performance arise out of a contract? If not, then the claim does not fall within the ambit of Section 46, subsection 2c. Secondly, is an alternative claim for the payment of damages attached to the claim for specific performance? If so, the claim does not fall within the ambit of Section 46, subsection 2c, and the claim may be brought in the Magistrates' Courts. Number 3. Is the claim for the rendering of an account? If so, then the claim is an exception to the Section 46, subsection 2c, and the claim may be brought in the Magistrates' Courts, provided that the account is for 200,000 Rand or under. And lastly, is the claim for delivery or transfer of property? If so, then the claim is an exception to Section 46, subsection 2c, and the claim may be brought in the Magistrates' Courts, provided that if the value of the property is over 200,000 Rand, both parties have consented in writing to the jurisdiction of the Magistrates' Courts. 2.4. The area to which the claim may be linked, as per Section 28. One should know that a matter may be brought in the Magistrates' Courts. The next question you need to ask yourself is, which particular Magistrates' Court or court has or have jurisdiction to hear this matter? The issue is addressed by Section 28 of the Magistrates' Courts Act 32 of 1944 and involves tying the matter in question to the area of jurisdiction of a particular Magistrates' Court or courts. In most cases, the jurisdiction of a particular Magistrates' Court is established by asking the following questions. First, does the defendant reside, carry on business, or is he employed within this particular court's area of control? Or secondly, did the cause of action arise wholly within this particular court's area of control? If the answer to either of the two questions is yes, then the court in question does have jurisdiction. Let us look at at each of these grounds of jurisdiction one by one. 2.4.1 Defendant's residence or business or employment as per Section 28 subsection 1a. Section 28 subsection 1a states that a magistrate's court will have jurisdiction over any person who resides or carries on business or is employed within the district or regional division over which that particular magistrate's court exercises jurisdiction. Let us take a closer look at the meaning of each of the above terms. 2.4.1a Where does a natural person reside? There has been much debate over what is meant by the term residence when it applies to natural persons. For example, Harry is a gentleman of the road who sleeps on a different park bench every night. Where does he reside? The courts have not given a definitive answer to this question, since it is a practical issue to be decided on the particular facts of each case. The general approach of the courts is clear enough, as is evident in the following extract from the case of Beetle and Co. versus Bowley. When it is said of an individual that he resides at a place, it is obviously meant that it is his home, his place of abode, the place where he generally sleeps after the work of the day is done. When it comes to determining jurisdiction, it is not possible for a person to claim that he does not reside anywhere. As Smallberger stated in the case of Maine versus Maine, for purposes of jurisdiction, our courts do not recognize the concept of a vagabondus. It is possible, however, for a person to have more than one place of residence. For example, a student may spend part of the year residing at a university hostel or in digs, and the other part of the year at home with his parents. However, although the student may have more than one place of residence, it is not possible for him to reside in two places at one time. In order for a particular court to exercise jurisdiction over the student by virtue of his place of residence, the student must have been residing within the territorial area of jurisdiction of that court at the time legal proceedings were instituted, that is, at the time the summons or notice of motion was served. A further point to note is that you do not become a resident of a place if you are only visiting that place for a short period. For example, if you leave your home in Johannesburg to spend a 2-week holiday in Durban, you do not become a resident of Durban. Further, do not confuse the concept of residence with that of domicile. While it is possible to have more than one place of residence, it is not possible to have more than one place of domicile. Finally, note that choosing an address as a domicilium citandi et executandi does not mean that you reside at that address. 2.4.1b Where does a company or closed corporation reside? As strange as it may seem, for legal purposes, companies and closed corporations are said to reside at a particular place. In the case of certain closed corporations, it is even possible for the closed corporation concerned to reside at two different places at the same time. The best way to understand this is the somewhat confusing area of the law is to examine the legal position before and after the enactment of the Companies Act 71 of 2008. Prior to the enactment of the said Act, both companies and closed corporations were said to reside at either of two places. First, the place of central control of the company or closed corporation, as well as, secondly, the place where the registered office of the company or closed corporation was located. The place of central control of a company, referred to in point 1, was taken to mean the place where its general administration is located, that is, at the seat of its central management and control, from where the general superintendence of its affairs takes place, and where, consequently, it is said that it carries on its real or principal business. The registered office of a company or closed corporation referred to in point 2 was and still is the office listed in the official forms used when a company or closed corporation was registered. Before the enactment of the Companies Act 71 of 2008, it was possible, in the case of both companies and closed corporations, for the registered office to be situated in one place, often for convenience the address of the financial or legal advisors who did the paperwork informing the company or closed corporation, and the place of central control or head office or principal office, if you prefer, to be situated in another place. Both places would count as the place of residence of the company or closed corporation concerned, but the legal position appears to have changed with the enactment of the Companies Act 71 of 2008. Note, however, that the change appears to have affected only companies and not closed corporations. The old legal position sketched above, that is, two possible places of residence, still seems to apply in the case of closed corporations. Let us now turn our focus to companies in particular and examine the current legal situation. That is, after the enactment of the Companies Act 71 of 2008, with regard to where companies may be said to reside for legal purposes. In the important case of Sibakulu Construction Proprietary Limited versus Wedgwood Village Golf Country Estate Proprietary Limited, Nedbank Limited intervening, the High Court held that for purposes of ascertaining jurisdiction, a local company resides only at the place of its registered office. In other words, according to this judgment, it is no longer possible for companies operating in South Africa to reside in two different places in the country at the same time. If you wish to use residence as a ground of justification over a company, you must be able to show the court concerned that the registered office of the company, that is, the address which appears in the official records, is situated within the territorial jurisdiction of that court. Section 23, subsection 3 of the Companies Act 71 of 2008 does require every company operating in South Africa to, first, continuously maintain one office in the country, and secondly, register the address of its office or principal office if it has more than one office. This means, in effect, that the Companies Act requires the registered office of a company to be its principal office, with the principal office indicating, using the old pre-2008 expressions which all convey the same idea, the place of central control, a head office, or principal place of business. If you are proceeding against a company, however, it would seem that you do not need to concern yourself with whether or not that company has complied with this provision. If you wish to use the residence of that company to establish jurisdiction, all you need to concern yourself with is the address which is listed in the official records as the registered office of that company. The registered office is now taken to be the one and only residence of the company. It is worth quoting the Sibakulu construction case at some length in order to reinforce the above points. The 2008 Companies Act retains the institution of a registered office, being an address at which the outside world can transact with the company effectively. A material distinction between a registered office under the 2008 Act and its predecessors, however, is that under the current Act, the registered office must be the company's only office. Alternatively, if it has more than one office, its principal office. The term principal office is not specially defined in the statute. It seems from the context, more particularly the requirements of what must be kept or accessible there, that it is intended to denote the place where the administrative business of the company is principally conducted, in the sense of being the place where the company's general administration is centered. In other words, the company's principal place of business, in the sense described in T.W. Beckett and Co. Limited versus H. Krumer Limited. This, whereas the 1973 Companies Act expressly acknowledged the possibility of a distinction between a company's registered office and its main place of business, the 2008 Act requires the registered office and the principal place of business for jurisdictional purposes to be at one and the same address. The apparent object of the provision, that is Section 23, subsection 3 of the Companies Act 71 of 2008, appears to be to end the potential for a company to have more than one place of residence for jurisdictional purposes, and that the statute should not be interpreted in a manner that would defeat its evident objects. For purposes of jurisdiction, a local company resides only at the place of its registered office, and the reasoning which led to a different conclusion in Dairy Board and Bison Board is no longer supported by the current statutory framework. The place of a company's registered office is objectively ascertainable. Any dispute as to whether the registered office should be at a different address by reason of an argument that the actual location of the company's principal office is elsewhere is a matter that is not, primarily at least, intended to be one to concern the courts, being a matter, if it arises, falling instead to be determined and corrected administratively by the Companies and Intellectual Property Commission under the provisions of Part D of Chapter 7 of the 2008 Act. 2.4.1 C. Where does a partnership reside? Unlike a company or a closed corporation, a partnership is not a legal person. One would think, therefore, that it is not possible for a partnership as such to have a residence, but this is not the case. In terms of Section 2 of the Interpretation Act, a partnership is defined as a person. Although this does not make a partnership a legal or juristic person, the Supreme Court of Appeal has held that if the principal place of business of a partnership, that is, the place of its central management and actual control, is located within the area of jurisdiction of a particular court, that should be sufficient to confer jurisdiction on that court. A partnership resides for jurisdictional purposes at the place where its principal place of business is situated. 2.4.1 D. Where does the state reside? It may be argued that the residence of the state is Pretoria, but there is at present no absolute certainty on this point. 2.4.1 E. What does carries on business mean? There is no general test to determine where a defendant carries on business. In each case, the operations of the defendant must be considered to determine what the business is, that is, what it does. For example, a logistics company and a manufacturing business conduct very different operations, and in determining where each carries on business, different considerations will be relevant. According to Jones and Buckle, the phrase carries on business in Section 28, subsection 1a, implies that business is conducted in a particular place from day to day, which involves regularity. Although a person may carry on business in more than one district or regional division at a time, a person whose permanent place of business is situated in one district or regional division, but who temporarily carries on business in another district or regional division, cannot claim that the latter district or regional division is his or her place of business. For example, a building contractor who is building houses in 3 or 4 different areas cannot be said to be carrying on business in each of those areas, since his business at those places is only temporary. An individual need not have a place of business at a particular place in order to be said to be carrying on business at that place. It is submitted, for example, that a fruit seller who sells fruit from the back of a bakkie and travels from place to place on the same fixed route year after year may be said to carry on business at each of his stops on that fixed route. In this case, although the fruit seller does not have a particular place of business in the sense of business premises, the regularity with which he conducts his business at each place alongside his fixed route would allow each of his stops to qualify as a place at which he carries on business. One would think that the same reasoning would apply in the case of a company or closed corporation. Assume that a clothing company has 5 major retail outlets. Surely each of these outlets would qualify as a place where the company carries on business. However, in the case of Minister of Law and Order versus Patterson, Robbie held that the place of business of a trading corporation is restricted, for jurisdictional purposes, to the place where its central management is exercised. In the case of accident insurance Corporation South Africa Limited versus Bonambi, Friedman disagreed with the decision reached in the Patterson case, but considered himself bound by the decision. The difficulty in moving away from the position taken by Robbie in the Patterson case was articulated by Friedman as follows. Even if I were free to reconsider the question of where a company carries on business for jurisdictional purposes, I am by no means certain precisely where a line falls to be drawn. Clearly, convenience dictates that some sort of limitation should be placed upon the meaning of the expression, but to formulate such a limitation, if one abandons the notion of the place where the central management and control of the company actually abides, is fraught with evident difficulties. For every formulation, one may be tempted to suggest one can think of numerous anomalous results which could conceivably follow. It may well be, therefore, that in the case of a company, one should in fact equate the place where it carries on business to its residence. The current position, therefore, seems to be that in relation to companies and closed corporations, the phrase carries on business in Section 28, subsection 1a is superfluous, because the meaning of this phrase, as interpreted by the courts, is subsumed by the meaning of resides, as interpreted by the courts. You would think that the state could be said to carry on business at every state office throughout the country. In Minister of Law's Law and Order versus Patterson, Robbie assumed, without deciding the matter, that the state does not carry on business in the normal commercial sense of the expression. However, for the sake of convenience and certainty, the court adopted a similar approach to that pertaining to companies. That is, the state is deemed to carry on business at the place where its central management and control abides. This would seem to be Pretoria. 2.4.1f. What does "is employed" mean? Here we are dealing with people who are employed by others, rather than those who carry on business for their own account. Some permanence is required. For example, a person who is normally employed in one district, but goes to another district for a day or two to perform some other task, or another, cannot be said to be employed in the latter district for jurisdictional purposes. Remember, the date of the service of summons and not the issue of the summons is the time at which the incidence of jurisdiction is determined. 2.4.2 Cause of action arising wholly. Section 28, subsection 1d. Section 28, subsection 1d states that magistrates' courts will have jurisdiction over any person if the cause of action arose wholly within the district or regional division. The phrase "if the cause of action arose wholly within the district" was defined as follows by the Appellate Division in the case of Mackenzie versus Farmers Cooperative Meat Industries Limited. Every fact which it would be necessary for the plaintiff to prove, if transversed, in order to support his right to the judgment of the court. It does not comprise every piece of evidence which is necessary to prove each fact, but every fact which is necessary to be proved. In other words, if you want to rely on Section 28, subsection 1d for jurisdiction, then every fact which your client must prove in order to succeed in his or her claim must have arisen within the district or regional division of the magistrate's court in which you want to institute action. It does not matter if certain pieces of the evidence which are necessary to prove those facts arose outside the district or regional division of the particular magistrate's court. Therefore, it is important to distinguish between, first, the facts which must be proven in order to constitute a valid cause of action. In Latin, these are called facta probanda. And secondly, all the different bits of evidence that must be laid to prove the facta probanda. In Latin, these are called the facta probantia. As Ogilvy Thompson stated in the case of Dusheko versus Milburn, I venture to think that most difficulties will in practice be resolved in applying the definition stated in Mackenzie versus Farmers Cooperative Meat Industries Limited above to any given case. It is borne in mind that the definition relates only to material facts, and if at the time due regard be paid to the distinction between the facta probanda and the facta probantia. The crucial point to remember is that for a cause of action to arise wholly within the district or regional division of a particular magistrate's court, all the facta probanda, but not necessarily all the facta probantia, must have occurred within the district or regional division. The case of King's Transport versus Viljoen is a good illustration of the distinction between facta probanda and facta probantia. This case involved a motor vehicle collision which had taken place between the plaintiff's vehicle and the defendant's vehicle in Somerset West. At the time of the collision, the defendant's vehicle was being driven by one of the defendant's employees within the course and scope of his employment. In other words, the defendant was being sued on the basis of vicarious liability in his capacity as the employer of the driver of the defendant's vehicle. The plaintiff instituted the action in the district of Somerset West on the basis that the cause of action had arisen wholly in that district. The defendant disputed that the magistrates' courts at Somerset West had jurisdiction to hear the matter, claiming that the cause of action had not arisen wholly in the district of Somerset West. The defendant argued that since he was being sued on the basis of vicarious liability, the plaintiff not only had to prove events surrounding the collision, but also that the driver of the defendant's vehicle was in fact employed by the defendant. Since the employment contract between the defendant and the defendant's driver had been concluded in the magisterial district of Salt River, the defendant claimed that the cause of action in this case had arisen partly in Salt River and partly in Somerset West. The court did not accept this argument and found that the signing of the contract of employment between the defendant and his driver was part of the facta probantia of the case and not part of the facta probanda. It was not the fact of the signing of the employment contract, but the fact that the driver was acting within the course and scope of his employment at the time and place of the collision that formed part of the facta probanda of this case. The signing of the contract of employment was only part of the facta probantia, that is, a piece of evidence to be adduced to prove that the driver was acting within the course and scope of his employment at the time and place of the collision. Different considerations arise when the cause of action is based on a contract and where it arises in delict. A cause of action based on delict will usually, but not always, arise wholly in the place the wrongful act was committed. Usually, the wrongful act and the damage occur at the same time and place, but this is not always the case, leading to potential problems in relation to jurisdiction based on Section 28, subsection 1d. For example, assume that a manufacturer of cars negligently manufactures a car with defective brakes at a factory in Pretoria. The car is sold to someone in Durban and the brakes malfunction 3 months later while the car is being driven in Durban, causing serious injury to the person who bought the car. Where does the cause of action arise? The High Court grappled with a very similar problem in the case of Thomas versus BMW South Africa Proprietary Limited and concluded that the locus of a delict for jurisdictional purposes should be determined with reference to the materiality of and the number of the ingredients thereof which have occurred in a court's area of jurisdiction. It may be possible, using the logic advanced in Thomas versus BMW, to conclude that the cause of action in our example arose wholly in Durban. It must be borne in mind, however, that Thomas versus BMW was a matter dealing with High Court jurisdiction. In a magistrate's court matter involving a situation similar to that described in our example, it would be much safer for you to assume that part of the cause of action arose in Pretoria and the other part in Durban. This would mean that you could not rely on Section 28, subsection 1D for jurisdiction. Causes of action based on contract give rise to even more problems in practice. Jones and Buckle state, inter alia, as follows in relation to actions in contract. A plaintiff suing on a contract must ordinarily prove both the conclusion of the contract and its terms. It follows from the first requirement that both offer and acceptance must have been made in the same district, and if they were not, then the whole cause of action cannot be said to have arisen in any one district. If it is correct, however, that the conclusion of the contract is part of the facta probanda in cases based on contract, why does this mean that both the offer and acceptance must have been made in the same district? We respectfully submit that after a valid offer is made, that offer continues in existence until such time it is either accepted, rejected, or withdrawn. If the offer is accepted, it may be said that a valid contract has been concluded at the time and place of acceptance. That is generally when acceptance is communicated to the offerer. It is submitted that it is at least arguable that the time and place of the offer was first made are details which form part of the facta probantia. Of course, determining the time and place of the acceptance of an offer, which, as we have said, for jurisdictional purposes is the time and place of the conclusion of the contract, may give rise to certain difficulties. Usually, the offer is said to have been accepted at the time and place it came to the attention of the offerer. This is the so-called information theory of acceptance. For example, assume the offerer lives in Cape Town and the offeree lives in Durban. The offerer telephones the offeree and makes her an offer. The offeree says she will consider the offer. 2 weeks later, the offeree telephones the offerer and tells him that she accepts the offer. The offer may be said to have been accepted in Cape Town and at the time that the offerer heard the acceptance of his offer. The place of the conclusion of the contract is therefore Cape Town. Apart from the conclusion of the contract, remember that you will also have to prove that the contract was breached. The breach also forms part of the facta probanda. For jurisdictional purposes, the place of breach is usually the place where performance of the contract was due by the defendant who failed to perform, or the place where the defendant performed his obligations in a defective manner. Furthermore, apart from the place of conclusion and breach, the place in which the plaintiff performed his obligations under the contract, assuming such obligations were due to be performed before the defendant was to perform his obligations, may also form part of the facta probanda. All in all, you have a sequence of events in contractual matters which may look something like this: offer by the plaintiff, followed by acceptance by the defendant amounting to a conclusion of the contract, followed by performance by the plaintiff of his obligations under the contract, followed by failure to perform or defective performance by the defendant amounting to a breach of the contract. As we have submitted above, it may be possible to argue that the time and place the offer was first made should be regarded as details which form parts of the facta probantia. It may even be possible to extend this argument to the submission that the time and place the contract was concluded, as well as the time and place the plaintiff performed his obligations under the contract, should be regarded as details forming parts of the facta probantia. These arguments could perhaps be advanced by adopting the same logic as employed in King's Transport versus Viljoen and Harold versus Rand Debt Collecting Company. After all, is not the relevant question for jurisdictional purposes the following: at the time and place of the breach of contract, was there a valid contract in existence? The approach outlined above would afford a much wider scope to Section 28, subsection 1D of the Magistrates Courts Act than is at present the case. However, it is certainly not the legal position adopted by our courts at this time, and it is not our function in a book such as this to suggest changes to the law. To be safe, when relying on Section 28, subsection 1d of the Magistrates Courts Act for jurisdiction, you are advised to ensure that each and every one of the elements listed above occurred within the district or regional division of the particular magistrates' courts in which you intend to institute legal proceedings. We suggest that you examine the circumstances of the particular case in which you are involved and carefully analyze the relevant case law in light of the particular circumstances before reaching a decision in practice. 2.4.3 Other grounds of territorial jurisdiction. 2.4.3a Partnerships, as per Section 28(1)b. A magistrate's court possesses jurisdiction over any partnership which has business premises situated or any members whereof resides within the district or regional division of that magistrate's court. 2.4.3b Incidental proceedings, as per Section 28, subsection 1c. A magistrate's court has jurisdiction over any person whatever in respect of any proceedings incidental to any action or proceeding instituted in the court by such person himself or herself. In other words, if you start legal proceedings in a particular magistrate's court, you cannot object to the jurisdiction of that court in respect of any proceedings which are incidental to those proceedings. Deciding whether or not proceedings are incidental to the proceedings originally instituted may be difficult, especially in the case of counterclaims. You may be tempted to think that a counterclaim is always incidental to the original action, but this is not the case. According to Patterson, it is settled that incidental means arising out of the same facts. In other words, if a claim is reconvention, that is, the counterclaim by the defendant against the plaintiff, arises out of the same facts as the claim in convention, that is, the claim by the plaintiff against the defendant, the claim in reconvention will be incidental to the claim in convention. In terms of Section 28, subsection 1c, the magistrate's court in which the plaintiff brought his claim in convention will have jurisdiction to hear the defendant's claim in reconvention. Patterson gives the following examples of counterclaims which are incidental to the claims brought in convention. Typical instances would be where the dispute concerns a breach of contract and both parties claim the other is in breach, or where there is a claim for damages and the defendant in convention wishes to plead contributory negligence on the part of the plaintiff. It is often the case, however, that the counterclaim has nothing to do with the claim in convention. For example, assume A sues B for an alleged breach of contract, and that B wants to counterclaim for injuries sustained during an alleged assault on him by A. The counterclaim, assault resulting in injury, did not arise out of the same facts as the claim in convention, which was breach of contract. Therefore, the counterclaim is not incidental to the claim in convention, and B may not rely on Section 28, subsection 1c for jurisdiction. If we assume that A does not reside, carry on business, and is not employed in the district or regional division of the particular magistrate's court in which he has sued B, and that the alleged assault on B did not occur in that district or regional division, B will have to bring his action for assault not as a counterclaim, but as a separate action in a separate court which has jurisdiction to hear that claim. Jones and Buckle agree with this general approach and describe what they believe to be the scope of Section 28, subsection 1c as follows. It is submitted that the language used in Section 28, subsection 1c points to matters which are really incidents of the claim in convention, that is, interlocutory orders, orders for costs, issue of execution, setting aside of judgment, etc., and which may have to be made against a defendant as well as against a plaintiff. In regard to such incidental matters, a plaintiff may fairly be said to submit to the jurisdiction of the court wherein he issues summons. He must know that no case could be dealt with if one of the parties was at liberty to ignore necessary incidental orders of the court, and he must be taken to have agreed to that court hearing and disposing of such incidental matters. 2.4.3 C. Interpleader proceedings, as per Section 28, subsection 1e. Section 28, subsection 1e relates to jurisdiction in respect of interpleader proceedings. Later in this book, we will be dealing with interpleading proceedings in more detail. But for the moment, you may think of an interpleader as a procedure for dealing with the situation in which one person, the stakeholder, has possession of property which is not his, but which is being claimed by two other people, the claimants, each of whom claims exclusive ownership of the property. The stakeholder is not sure to which claimant he should give the property, and the stakeholder then uses the interpleader procedure to ask the court to decide this issue. In practice, the sheriff of the court often finds himself in the position of a stakeholder. What happens is that the sheriff goes out and attaches the property of a judgment debtor on behalf of a judgment creditor. Someone then pops out of the woodwork and claims that the property which has been attached does not belong to the judgment debtor, but in fact belongs to him or her. For example, the spouse of a judgment debtor married out of community of property may claim that the attached property belongs to him or her and not his or her spouse. Therefore, both the spouse and the judgment creditor lay claim to the attached property, and the sheriff is in the position of a stakeholder. In terms of Section 28, subsection 1E1, if the person who had the goods attached, that is, the execution creditor, as well as all the claimants to the goods, that is, the spouse of the execution debtor in our example, reside or are employed or carry on business within the district or regional division of a particular magistrate's court, then that court will possess jurisdiction to hear interpleader proceedings in relation to the goods attached. In terms of Section 28, subsection 1E2, the court out of which the warrant of execution was issued will possess jurisdiction to hear the interpleader claim. Once a warrant of execution is issued, the property of the judgment debtor may be attached within the district of another court. If this happens, it is clear from the wording of Section 35, subsection 2, that an interpleader summons may be issued out of the court of the district in which the judgment debtor's property was attached. In other words, when Section 28, subsection 1E2 and Section 35, subsection 2 are read together, both the court out of which the warrant of execution was issued, usually the court which granted judgment in the matter, as well as the court within whose area the property of the judgment debtor was attached, will possess jurisdiction to hear interpleader proceedings in relation to that property. Section 28, subsection 1E3 relates to interpleader proceedings taken under Section 69, subsection 2 of the Magistrates Courts Act. That is, those situations in which two or more persons make adverse claims to any property in the custody or possession of a third party. In other words, this subsection deals with interpleader claims generally, which do not involve attachments of the property claimed by the sheriff of the court. Here, the stakeholder is simply a person who has custody or possession of property which is claimed by two or more claimants. In terms of Section 28, subsection 1E3, the court within whose district or regional division the stakeholder resides, is employed, or carries on business, will possess jurisdiction to hear interpleader proceedings in relation to the goods in the custody or possession of the stakeholder. In terms of Section 28, subsection 1E4, If all parties to an interpleader matter consent to the jurisdiction of a particular magistrate's court, that court will possess jurisdiction to hear the matter. 2.4.3d. Consent, as per section 28, subsection 1f. If you are the defendant or respondent in a magistrate's court matter and you enter an appearance to defend or oppose the matter, and then take no objection to the jurisdiction of that court, it will be assumed that you consent to the jurisdiction of the court. This section gives recognition to the common law principle of submission to jurisdiction. Note that by simply entering an appearance to defend or oppose a matter, you are not consenting to the jurisdiction of the court. If you believe that the court does not possess jurisdiction, usually you will first enter an appearance to defend or oppose, to stop the other side taking default judgment against your client, and then follow up with a special plea which will be included with your plea on the merits, claiming that the court lacks jurisdiction. Note that jurisdiction cannot be conferred under section 28 subsection 1f where the matter is one which falls under section 46. Furthermore, it would seem that section 28 subsection 1f may not be used to circumvent the requirement that where the amount claimed is over 200,000 Rand or 400,000 Rand, as the case may be, in terms of section 45 subsection 1, the parties must consent in writing in order to bring the matter within the jurisdiction of the magistrate's courts. The matters listed in section 46, as well as those matters where over 200,000 Rand or 400,000 Rand, as the case may be, is being claimed and no written consent has been given, remain beyond the jurisdiction of the magistrate's courts. Even though the defendant does not object to the jurisdiction of the court, in such a case, the matter remains beyond the jurisdiction of that court. The court itself, miro mutu, must decline jurisdiction in such a case. Section 28 subsection 1f is thus restricted in its application. Despite this, the subsection may provide you with a very useful fallback position if you are acting for a plaintiff or applicant in a matter. In such a case, you will of course have relied on one of the other grounds of jurisdiction set out in section 28 subsection 1 of the Magistrates Courts Act. It may happen that, for some reason or other, the ground of jurisdiction upon which you were relying falls away. For example, it turns out that the defendant does not reside in the district or regional division as you thought he did, or that the cause of action did not arise wholly in the district or regional division as you believed. If the defendant enters an appearance to defend or oppose the matter, and then takes no objection to the jurisdiction of the court, you may be able to rely on section 28 subsection 1f for jurisdiction. 2.4.3 e. Immovable property, as per section 28 subsection 1g. A magistrate's court has jurisdiction over any person who owns immovable property within the district or regional division served by that court, in actions in respect of such property or in respect of mortgage bonds thereon. The learned authors of Jones and Buckle submit that, for the purposes of the section, a direct relationship between the action and the immovable property or mortgage bond thereon is required. 2.4.4 Divorce and related matters. Which particular regional magistrates court? As pointed out previously in section 2.2.11 above, certain regional magistrates courts have been granted jurisdiction to hear and determine suits relating to the nullity of a marriage or a civil union and relating to divorce between persons, and to decide upon any question arising therefrom, and to hear any matter and grant any order provided for in terms of the Recognition of Customary Marriages Act. As to the issue of which particular regional magistrates court may hear a particular matter, section 28 subsection 1a provides that, for the purposes of section 29 subsection 1b, a regional magistrates court shall have jurisdiction if the parties are, or if either of the parties is domiciled in the area of jurisdiction of the court on the date on which proceedings are instituted, or ordinarily resident in the area of jurisdiction of the court on the said date, and has or have been ordinarily resident in the Republic for a period of not less than 1 year immediately prior to that date. Number 3. High Court Jurisdiction. 3.1. General Overview. The power of the High Court is embodied in Section 169 of the Constitution. This section empowers the High Court to decide any matter apart from certain matters specifically excluded from its jurisdiction. As far as cases that do not involve constitutional issues are concerned, the only matters which may not be decided by the High Court are those assigned to another type of court by an Act of Parliament. In relation to constitutional matters, there are two types of matters which may not be decided by the High Court. Firstly, it may not hear matters which only the constitutional courts may decide. Secondly, it may not hear matters which the constitutional court has agreed in the interests of justice to hear directly in terms of Section 167, subsection 6a of the Constitution, and those which have been assigned by an Act of Parliament to another court of a status similar to that of the High Court. The jurisdictional power of the High Court is further regulated in terms of Section 21 of the Superior Courts Act, previously Section 19 of the Supreme Court Act. For purposes of this introduction, it is sufficient to focus on the following important extract from this section. A division has jurisdiction over all persons residing or being in and in relation to all causes arising and all offences triable within its area of jurisdiction, and all other matters which it may, according to law, take cognizance. Our courts, referring to very similar wording in Section 19 of the old Supreme Court Act, have held that the phrases used broadly restate the common law position. Crucially, our courts have interpreted the term causes arising, as it appears in the above extract, to mean not causes of action arising, but legal proceedings duly arising. A proceeding which duly arises in a court is one over which that court has jurisdiction according to common law. In other words, to make a long story short, the manner in which our courts have interpreted Section 19, subsection 1 of the Supreme Court Act, the old statutory basis for jurisdiction, and now Section 21 of the Superior Courts Act, the new statutory basis, leads us back to the common law. Another way to explain this would be to point out that the intention of the legislature in enacting Section 21 of the Superior Courts Act and its predecessor, Section 19 of the Supreme Court Act, both of which are drafted in essentially identical terms, was not to codify the jurisdiction of the High Court, but rather to interfere as little as possible with the common law in this area. It is to common law that we must turn in order to establish the fundamental principles of High Court jurisdiction, bearing in mind that there may be certain statutory provisions which alter the common law position in specific areas. In approaching this complex topic, we shall start by dealing with the doctrine of effectiveness, the most important general principle underlying High Court jurisdiction. With this general principle in mind, we shall discuss the three foundations or grounds of High Court jurisdiction in terms of the common law, termed rations in Latin, which are most commonly employed in practice to establish the jurisdiction of a particular court. First, ration domicili, that is, defendant or respondent is domiciled or resident in the court's area. Second, ration res gestae, that is, the cause of action arose in the court's area. And ration re setae, that is, the property involved in the claim is situated in the court's area. Having dealt with the above three grounds of jurisdiction in the abstract, we shall discuss the practical application of these grounds in the context of the two most common types of claims which arise in practice, namely, first, claims relating to property, and secondly, claims sounding in money. Then we shall proceed to discuss the jurisdictional principles applicable to certain additional claims, some of which are common in practice and others less so. We feel that it is advisable to deal with these claims under a separate heading in order to keep your mind map as user-friendly as possible. The additional claims are the following. First, claims against defendants or respondents who are neither domiciled nor resident in this country. Such a defendant or respondent is termed a foreign peregrinus. In the case of a claim sounding in money against a foreign peregrinus, an attachment to found or confirmed jurisdiction ad fondandum confirmandum jurisdictionem is required. Further, the principle of consent to jurisdiction prorogatio arises most pertinently in relation to claims of this type, and will be discussed under this section. Secondly, matrimonial claims. The common law grounds of jurisdiction are not applicable in the case of claims brought in terms of the Divorce Act, since jurisdiction is regulated by the said Act. Third, claims for interdicts. Specific jurisdictional principles apply in such cases. And fourth, single claims involving two or more jurisdictions. In such cases, it may be possible to rely on the so-called Russian causa continentia to ground jurisdiction in one or other of the courts involved. Having dealt with the jurisdictional principles applicable to the additional claims listed above, we shall conclude our examination of High Court jurisdiction with an extended discussion of inherent jurisdiction. Inherent jurisdiction is a discretionary power held by the High Court to prevent injustice in certain situations. 3.2. The Doctrine of Effectiveness. The doctrine of effectiveness is the most important general principle underlying the jurisdiction of the High Court in the majority of cases. The basic idea behind this doctrine is that you should not waste a court's time by bringing a particular matter before it if it is clear from the outset that the court's judgment will not be effective. The second edition of Pollock on jurisdiction emphasizes the fundamental importance of the doctrine of effectiveness, quoting the court in Termo Radiant Oven Sales Proprietary Limited versus Nelspruit Bakeries. Save for the principle of voluntary submission to jurisdiction and possibly in the case of the exclusive competency of the court of domicile in an action affecting status, the basic principle of jurisdiction in our law is that of effectiveness. An effective judgment is one which can be enforced. To enforce its judgment, a court needs to have control over the judgment debtor's person or property. In most cases, judgments are enforced by means of a writ of execution, in terms of which the sheriff of the court attaches and sells the defendant's property to secure payment, in part or in full, of the judgment debt. In some cases, judgments are enforced by means of a writ of arrest, in terms of which the judgment debtor is arrested and charged with contempt of court. Although the doctrine of effectiveness is the most important doctrine underlying High Court jurisdiction, it is not the only such doctrine. The doctrine of voluntary submission to the jurisdiction of the court, prorogatio, may also be regarded as underpinning High Court jurisdiction, although to a much more limited extent. As van Schalkwyk stated in the case of Utah International Incorporated versus Hanneth and others, the doctrine of consent is, of course, largely incompatible with the doctrine of effectiveness, but like effectiveness, it is part of our law and on the ascendancy. We deal with the principle of submission to jurisdiction later in this section. 3.3. The most common grounds of High Court jurisdiction. At the outset, it is worth quoting from the seminal judgment of de Villiers in the case of Einwald versus the German West African Company, in which the learned former Chief Justice commented as follows on the various rationis jurisdictionis recognized by our common law. What then are the grounds upon which the jurisdiction of this court can be exercised in respect of any contract over any defendant without his consent, expressed or implied? The grounds are threefold, viz. By virtue of the defendant's domicile being here, by virtue of the contract either having been entered into here or having to be performed here, and by virtue of the subject matter in an action in rem being situated in this colony. The threefold division referred to by de Villiers will be followed in our discussion of the various grounds of jurisdiction, that is, ration domicili, ration register, including ration contractus and ration delicti commissie, and ration re sete. 3.3.1 Ration domicili. In terms of the general common law principle expressed by the Latin term acta sequitur forum rei, the plaintiff or applicant must follow the defendant or respondent to the defendant or respondent's place of domicile or residence, and institute action against him there. The court which exercises territorial jurisdiction over the area within which the defendant or respondent is either resident or domiciled is known as the forum domicili. In order to claim jurisdiction by virtue of the ration domicili, you must institute legal proceedings against the defendant or respondent in the forum domicili. When dealing with the High Court jurisdiction, it is important to note that either domicile or residence is sufficient to constitute a particular court as the forum domicili. This was definitely decided by the Appellate Division in the case of Bison Board Limited versus K. Braun Woodworking Machinery Proprietary Limited, in which Hoekster stated as follows: provided that the defendant is an insular of the court's area of jurisdiction, the court will be prepared to hear the case. Accordingly, if the defendant is either domiciled or resident in the area, this will be a sufficient jurisdictional connecting factor. Neither of these requirements predictates the actual physical presence of the defendant within the court's area. If the defendant is present, he may be brought to court by summons in the ordinary manner. If he is absent, then, subject to the rules of court, summons may be effected by edictal citation or substituted service, as the case may be. Domicile and residence suggest no more than a notional connection with the court's area. Absence is relevant only in regard to the procedural matter of service. Having dealt with the meaning of residence in our discussion relating to the jurisdiction of the magistrates' courts, let us now turn to a discussion of the meaning of domicile in terms of the Domicile Act. A domicile of choice shall be acquired by a person when he is lawfully present at a particular place and has the intention to settle there for an indefinite period. According to Justice Chetty, in the case of Chinatex Oriental Trading Corporation versus Erskine, a domicile of choice may be acquired if the following two elements are satisfied. First, physical presence, that is, an objective fact, and secondly, an intention to remain indefinitely, a subjective test. According to the learned judge, a person's physical presence requires more than a visit or a sojourn to the country. Accordingly, the longer the person is settled at a particular place, the greater the likelihood of a court regarding him as resident there for the purposes of domicile. The second element, animus monendi, does not require an intention to remain permanently. The person must display a state of mind which is consistent with the intention of remaining indefinitely, which intention need not be irrevocable in order to show that a domicile of choice has been acquired. According to one legal academic, an unfortunate result of the statutory intention requirement to settle for an indefinite period is that residence for a limited period or for a specific purpose, even though it may involve a very lengthy period, will be excluded. This means that a person may reside at a particular place for a period of 10 years in terms of a contract of employment, for example, and not be able to acquire a domicile there. Note that whereas it is possible to have more than one place of residence, for example, a university student who resides in a university residence for part of the year and at home for the rest of the year, it is not possible to have more than one place of domicile. If you wish to institute legal proceedings against the university student mentioned in the example using his place of residence in order to found jurisdiction, you must make sure that the student is actually residing within the area of jurisdiction of the court out of which you have issued the summons or notice of motion at the time of the legal proceedings are instituted, that is, the date of service of the summons or notice of motion. Once jurisdiction has been established, it continues to exist until the end of the matter, even if the grounds on which jurisdiction was established no longer exist. For example, if a woman were to leave the jurisdiction of a division in which she had instituted divorce proceedings, the division in question would still have jurisdiction to adjudicate upon the matter. Finally, note that a person does not lose his domicile until he has acquired another domicile. So, assume that a person is domiciled in country A, but then leaves country A with the intention never to return. Assume further that he starts to travel the world looking for another country in which to settle down. In this case, he will remain domiciled in country A until he settles down in another country. That is, he is physically present in that country and forms the requisite intention to remain indefinitely in that other country. That is, he has the requisite intention to acquire a domicile of choice as explained above. 3.3.2 Ration re gestae. In terms of res gestae simply means thing done, although the term is generally used in somewhat narrower sense to refer to the acts or transactions in issue in a particular case, or the critical events, in essence, the facta probanda. The idea behind the Russian re gestae is that a court will have jurisdiction to hear a particular matter if the critical events relating to that matter took place within its area. In other words, if the relevant cause of action arose in that area. The court which exercises jurisdiction over this area is known as the forum re gestae. As pointed out earlier, the term cause of action has been defined in numerous cases. In the case of Abramse and Sons versus South SA Railways and Harbours, for example, it was described as follows. The proper legal meaning of the expression cause of action is the entire set of facts which give rise to an enforceable claim and includes every fact which is material to be proved to entitle a plaintiff to succeed in his claim. It includes all that a plaintiff must set out in his declaration in order to disclose a cause of action. However, Pistorius in Pollack on jurisdiction pointed out that although the term cause of action has been defined, our courts have not attempted to define the circumstances in which the cause of action may be said to arise within a particular area. Although it is clear that for the purposes of High Court jurisdiction, unlike the Magistrates Court, it is not necessary for all the facta probanda to have occurred within the jurisdiction of the relevant court. It is not entirely clear whether, in a case where the different elements of a cause of action occurred in different areas of jurisdiction, a cause of action may then be said to have arisen in each and every area where the different elements occurred, or whether there is one specific area where it is proper to speak of this cause of action as having risen. It is beyond the scope of this book to do more than allude to the difficulties involved in this area of the law, and you would be wise to conduct thorough research before litigating in practice. For practical purposes, however, it is submitted that for jurisdictional purposes, first, a contractual cause of action arises, number 1, where the contract was concluded, the locus contractus, and number 2, where the contract was to be performed, either in whole or in part, the locus solutionis. Secondly, you may therefore proceed in the forum contractus, that is, the court of the place in which the contract was concluded, or the forum solutionis, that is, the court of the place in which the contract was performed. Note, however, that the term forum contractus is often used in a wider sense to mean both the court of the place in which the contract was concluded, as well as the court of the place in which the contract was to be performed. In the case of Veneta Mineraria Spa versus Carolina Collieries Proprietary Limited, Kumblebane provides the following clear summary of the meaning of the term forum contractus in this wider sense. It is well established that for breach of contract, a plaintiff may sue in the court of the place where the court was entered into, the forum contractus, which in the wide sense is understood to include the place where the contract is to be performed. Then there's multiple cases. In the last mentioned decision at 463, it is pointed out that when the place of performance is relied upon for jurisdiction, the breach in respect of which the defendant is sued must be a breach of duty which he was found to perform within the jurisdiction. In other words, the contractual right infringed must be anchored in a contract that has a direct connection with the area of jurisdiction of the court. Third, in accordance with the above, in matters involving breach of contract, you would be wise, for jurisdictional purposes, to proceed either in the court within whose area of jurisdiction the contract was concluded, or in the court within whose area of jurisdiction the contract was to be performed. Usually, the place of breach will coincide with the latter area. If for some reason it does not, for example, the contract was repudiated somewhere else, and the repudiation is the breach relied on, it is probably still safer to stick with the court within whose area of jurisdiction the contract was concluded, or in the court within whose area of jurisdiction the contract was to be performed. In the Veneta Mineraria Spa case referred to above, Kumbleben states that, firstly, our courts have consistently given this ground, that is, the ration contractus, in the wider sense discussed above, a circumscribed and well-defined meaning. Secondly, as a matter of policy, the fact of repudiation at a particular place does not appear to me to be sufficient reason for exercising jurisdiction when, in all other respects, the contract in question is unrelated to the court of that area. Fourth, a delictual cause of action arises where the delict was committed or occurred. The court which exercises jurisdiction in this area is termed the Forum Delicti Commissi, and it is said to have jurisdiction by virtue of the Russian Delicti Commissi. In the vast majority of delictual cases, the damage follows the wrongful act directly and materializes at the same place. If someone negligently drives into your car and damages it, for example, it is clear that the delict was committed when and where the accident took place. Occasionally, however, the wrongful act happens in one place, while the damage arises later in another place. For example, suppose a worker in a KwaZulu-Natal motor vehicle factory deliberately sabotages the brakes of a vehicle he is assembling. The brakes malfunction 2 weeks later as the vehicle is being driven at a high speed in Mpumalanga, causing injury there. In such a case, the locus of the delict for jurisdictional purposes will be determined with reference to the materiality of and the number of the ingredients thereof which occurred within the different areas of jurisdiction. This was the position taken by Van Reenen in the case of Thomas versus BMW South Africa Proprietary Limited, in which he states as follows. The most apparent solution to the problem of determining the locus of a delict for jurisdictional purposes appears to be to devise qualitative and quantitative criteria to determine, with reference to the elements of the delict in question, to the extent that it is possible to break a delict up into metaphysical components, the court which is the most closely associated with the delict, the locus whereof has to be determined, Such criteria, however, should accord with the principles of our common law regarding jurisdiction, be consonant with the developments in our case law, and accommodate the demands of modern society. Bearing all this in mind, the locus of a delict for jurisdictional purposes, in my view, should be determined with reference to the materiality of and the number of the ingredients thereof which have occurred in a court's area of jurisdiction. In the case of other causes of action, jurisdiction is determined according where the res gestae occurred, and whether there are sufficient connecting factors between the matter in question and the relevant court to enable the court to hear and determine the matter. The term ration re gestae is sometimes used in a narrow sense, and may be distinguished from the more specific rationis contractus and delicti commissii. At other times, the term ration re gestae is used in a broad sense, which includes these two specific grounds of jurisdiction. It is not entirely clear which is the more appropriate use of the term, but it is as well to be aware of the different ways in which it is used. 3.3.3 Ration re gestae. The court which exercises territorial jurisdiction over the area within which it is situated, movable or movable property constituting the subject matter of the claim is known as the forum re gestae. In order to claim jurisdiction by virtue of the ration re gestae, the movable or immovable property constituting the subject matter of the claim must be situated within the forum re gestae. 3.4 The two most common types of claims. 3.4.1 Claims relating to property. 3.4.1a What is a claim relating to property? In these cases, the court is asked to make an order which directly affects specifically identified property. In practice, there are many different types of claims relating to property, but we shall restrict ourselves to those claims dealing first with the title to property and second with transfer or delivery of property. We shall deal with these two types of claims both in respect of movable and immovable property. Claims involving title to immovable property include claims for ownership or possession of immovable property. For example, I have occupied this piece of land for a continuous period of 30 years. Therefore, I have become the owner due to acquisitive prescription. I want the court to order the Registrar of Deeds to alter the title deeds to reflect that I am now the owner of the property. Or a much more common claim in practice. I own this house. The lease in terms of which you were occupying my house has come to an end. Since you refuse to leave, I shall seek an order of ejectment from the court in order that possession of my house may be restored to me. Claims for the transfer of immovable property in terms of a contract entered into between two parties are common in practice. For example, I have bought and paid for this piece of land in terms of a contract entered into between us, but you refuse to sign the necessary documents to enable the property to be transferred to my name. I shall ask the court to order that the property be transferred into my name. Claims involving title to movable property are also common in practice. For example, I am the owner of this motor vehicle. You borrowed it from me, but now you refuse to return it. I shall ask the court to order that the motor vehicle be returned to me. Claims for the delivery of movable property are probably the most common of all claims relating to property in practice. For example, we agreed that I would buy your car for 110,000 rand. I have paid you the 110,000 rand, but you have not delivered the car to me. I shall ask the court to order that you deliver the car as agreed. In each of the above examples, the claim relates to property, either movable or immovable, and not to money. 3.4.1b Which of the grounds of jurisdiction apply? 3.4.1b1 Immovable property. Claims involving title. As far as claims involving the title to immovable property are concerned, it is clear that the forum re gestae will possess jurisdiction to hear such claims. Further, despite some evidence to the contrary in the cases of Higo versus Vessels and Ward versus Burgess, it would seem that the Forum Rei Cité is the only court which will possess jurisdiction in such matters. 3.4.1b2 Immovable property. Claims for transfer. In relation to claims for the transfer of immovable property, once again it is clear that the Forum Rei Cité will possess jurisdiction to hear such claims. As to the question of whether or not any other court or courts will possess jurisdiction in such matters, the answer seems to depend upon whether the action is in rem or in personam. According to the following extract from Pollock on jurisdiction, it would seem that the Forum Rei Cité will exercise exclusive jurisdiction in relation to an actio in rem for the transfer of immovable property, but will share jurisdiction with other courts, for example the Forum Domicili, in relation to an actio in personam for the transfer of immovable property. It is submitted that a provincial or local division of the Supreme Court, that is, the High Court, has no jurisdiction to enter an action in rem in which the transfer of immovable property is claimed if the property is situated outside the area over which such division exercises jurisdiction. If, however, the court has jurisdiction over the defendant on recognized common law grounds, it can, in an action in personam, compel him to take whatever steps are necessary to fulfill an obligation to transfer immovable property situate outside the area over which the court exercises jurisdiction. 3.4.1b3 Movable property. Claims involving title. As far as claims involving title to movable property are concerned, it is clear that the Forum Rei Cité will possess jurisdiction to hear such claims. Note that although the property must be situated within the area over which the court exercises jurisdiction at the time legal proceedings are instituted, the court will not be deprived of jurisdiction if the property is then removed from its area of jurisdiction. As to the question of whether or not any other court or courts will possess jurisdiction in such matters, the following is stated in Pollock on jurisdiction. The Forum Rei Cité does not have exclusive jurisdiction to determine the title to movables in the Republic. According to Foote, the Forum Domicili of the defendant may also entertain such an action, if the movable property, though outside the area of the court concerned, is situate in the Republic. There seems to be no reason why the Forum Domicili should not also have jurisdiction to determine the title to property in a claim where the defendant is an insula, that is resident or domiciled within the area of jurisdiction of the court in which legal proceedings were instituted. 3.4.1b4 Movable property. Claims for delivery. In relation to claims for the delivery of movable property, once again it is clear that the Forum Rei Cité will possess jurisdiction to hear such claims. The Forum Rei Cité does not, however, possess exclusive jurisdiction in such matters, provided that the property is situated within the Republic. The Forum Domicili of the defendant will also possess jurisdiction in a claim for delivery of movable property. Furthermore, according to the learned author of Pollock on jurisdiction, other courts which exercise jurisdiction over the defendant on some recognized ground, for example ration contractors, may also possess jurisdiction in such matters. If movable property, although outside the rechtskring of the court, is within the Republic, it would seem that any division, though it be neither the Forum Domicili nor the Forum Rei Cité, will have power to order the delivery of movable property if it has jurisdiction over the defendant on some recognized ground. For instance, if a contract for the delivery of that property were concluded within the area over which the court exercises jurisdiction, then there is no reason in principle why the court which can exercise jurisdiction over the defendant, ration contractors, should not also have the power to order the delivery of the property. For purposes of jurisdiction in respect of incorporals, South African law distinguishes between movable and immovable incorporals. In relation to immovable incorporals, the forum racete has exclusive jurisdiction. For this reason, the South African High Court does not have jurisdiction in respect of foreign intellectual property rights, which are territorial, immovable intangibles. 3.4.2 Claims sounding in money. 3.4.2a What is a claim sounding in money? In these cases, a plaintiff is seeking payment of money. It is probably safe to say that the vast majority of actions brought in our courts sound in money. In some cases, the claim for money will be brought on its own. For example, a contractual claim. We agreed that you would buy my car for 410,000 rand. I have given you the car, but you have not paid me for it. Please pay me what you owe me. Or a delictual claim. You crashed into my car and damaged it. The fair and reasonable cost of repair amounts to 410,000 rand, and this is less than the difference between the pre- and post-collision value of the vehicle. Please pay me the fair and reasonable costs of repair. In certain cases, the claim for money will be brought as an alternative to some other claim. For example, as an alternative to a claim for specific performance. We agreed that I would buy your car for 410,000 rand. I have paid you the 410,000 rand, but you have not given me the car. Either give me the car as agreed, which is a claim for specific performance, or else give me my money back, which is a claim sounding in money as an alternative. In some cases, a claim for specific performance will be brought without a claim for money. For example, you agreed to build me a house for 620,000 rand. I give you the 620,000 rand, but now you refuse to build the house. I insist you build the house as agreed. It may seem odd to classify the last case as a claim sounding in money. For the purposes of the High Court jurisdiction, however, the principles applicable to such cases are the same as those applicable to claims sounding in money. Note that the specific performance referred to in this example does not involve the delivery of movable or immovable property. If the specific performance you were claiming involved the delivery of some kind of property, then your claim would be classified as a claim relating to property discussed above. 3.4.2b Which of the grounds of jurisdiction apply? The grounds of jurisdiction that apply to claims sounding in money depend, however, upon whether the defendant or respondent is an insular or a peregrinus of South Africa. An insular is a person who is either resident or domiciled within the court's area of jurisdiction. A peregrinus is the opposite of an insular, and is this a person who is neither domiciled nor resident within the court's area of jurisdiction. It is necessary to distinguish between the two kinds of peregrini. First, the first kind of peregrinus, who may be referred to as a local peregrinus, is a person who is a peregrinus of the court in question, but is resident or domiciled within the borders of South Africa. For example, a person who is resident in and domiciled in Cape Town is an insular of the Western Cape Division, but is a peregrinus of all the other divisions of the High Court in the country. Such person is, of course, an insular of South Africa. Second, the type of peregrinus who may be referred to as a foreign peregrinus is a person who is resident and domiciled in a foreign country, and is a peregrinus of South Africa as a whole. Note that nationality has nothing to do with it. For example, a citizen of France who has permanent residence rights in South Africa and is living in Cape Town is an insular of the Western Cape Division, and is not a peregrinus of South Africa. Do not be confused by the different uses of the terms insular and peregrinus. The distinction we are interested in at this stage is that between an insular and a peregrinus of South Africa. The majority of matters brought before our courts involve defendants and respondents and respondents who are insulae of South Africa. In such matters, that is, where the defendant or respondent is an insula of South Africa, in the case of a claim sounding in money, you may use either the ratio domicile or the ratio registay, including the Russian contractus and the Russian delicti to ground jurisdiction. However, different jurisdictional principles apply when the defendant or respondent is a peregrinus of South Africa. In such cases, an attachment to found or confirmed jurisdiction is required. This is dealt with below in our discussion on the jurisdictional principles applicable to certain additional claims. 3.5. The jurisdictional principles applicable to certain additional claims. 3.5.1. Claims sounding in money against foreign peregrini. In terms of Section 42, subsection 2 of the Superior Courts Act, the civil process of a division runs throughout the country. This means that the process issued by a particular division, for example, a summons or notice of motion, may be served within the jurisdiction of any other division of the Republic. It also means that the judgment or order of a particular court is enforceable in the jurisdiction of any other division in the Republic. The result is that even if a defendant or his property is situated outside the jurisdiction of a particular division, that court is able to exercise control over the person or property of the defendant, provided that he is an insula of South Africa. In those cases in which the defendant is a peregrinus of South Africa, however, neither the defendant nor any of his property may be in the country when judgment is given against him. This would render the judgment ineffective. Therefore, it is not surprising that in order to establish jurisdiction in the case of a claim sounding money against a foreign peregrinus, an attachment of such defendant's property is usually required. 3.5.1a. Attachments to found and confirmed jurisdiction. Before you are permitted to institute a claim sounding in money against a defendant or respondent who is a peregrinus of South Africa, it is usually necessary to acquire some sort of hold over that person. This is usually done by attaching his property. In order to understand why such attachment is necessary, think carefully about the category of persons who are classified as peregrini of South Africa. It is very important to remember that these persons are foreigners who are neither domiciled nor resident in South Africa. In other words, we are not talking about the Italian citizen who owns the pasta restaurant down the street from you, or about the Zimbabwean student who is studying at the University of Cape Town, or about the many other foreigners who reside in South Africa. Because these people reside in South Africa, they cannot be classified as peregrini of this country. A true peregrinus of South Africa is a person who is just passing through. His home is not here, that is, he is not a resident here, and he does not intend to stay here indefinitely, so he is not domiciled here. An example of such a person would be a German tourist who is traveling around the country for a few weeks, or a member of a visiting Ugandan sports team which is in South Africa to take part in a sporting competition. Now, let us assume that you want to bring a claim sounding in money against a person who may probably be said to fall into the category of a peregrinus of South Africa, that is, a foreign peregrinus. For example, a German tourist who is here on holiday crashes into the back of your client's car. Before a court takes on this kind of case, it will want to be sure that its judgment will be effective. One way to ensure the court's judgment will be effective is to attach the property of the German tourist before he returns to Germany. Note, however, that if the foreign peregrinus has no property to attach, there must be service on him while he is in South Africa, and there must be a sufficient connection between the suit and the court's area of jurisdiction. This exception is a fairly recent development to the common law, undertaken by the Supreme Court of Appeal in the case of Bid Industrial Holdings Proprietary Limited versus Strang and another the Minister of Justice and Constitutional Development as a third party. For the purposes of your mind map, you may divide attachments to found and confirmed jurisdiction into 4 simple steps. Step 1. For jurisdictional purposes, you are only required to make an application to attach the property of a defendant to found or confirmed jurisdiction if he or she is a peregrinus of South Africa. If the defendant is a local peregrinus, attachment is impermissible. In other words, attachments to found or confirmed jurisdiction are only required if the defendant is neither resident nor domiciled in this country. According to Section 28 of the Superior Courts Act, no attachment of property to found jurisdiction shall be ordered by a division against the person who is resident in the Republic. Step 2. Once you know that you are dealing with a defendant who is a peregrinus of South Africa, that is, a foreign peregrinus, which means that you are entitled to carry out an attachment to found or confirmed jurisdiction, you must ask yourself the following 2 questions. First, within the territorial jurisdiction of which court or courts did the cause of action arise? Secondly, within the territorial jurisdiction of which court or courts is the plaintiff domiciled and or resident? And step number 3, depending on the answers to the questions set out in step 2, you will then make an application to court to order an attachment of the defendant's goods to either found or confirmed jurisdiction. An application for an attachment to confirmed jurisdiction ad confirmandum jurisdictionem may be brought in any court which exercises territorial jurisdiction over an area within which part of the cause of action arose. In other words, you are confirming a ground of jurisdiction, ration res justae, which already exists. An application for an attachment to found jurisdiction ad fondandum jurisdictionem may be brought in the court which exercises territorial jurisdiction over the area within which the plaintiff is either domiciled or resides, unless part of the cause of action also arose in that area, in which case the application will be for an attachment to confirm jurisdiction. You may choose whichever court is most convenient for your client. If your application is successful, the attachment may be carried out in any part of South Africa. Step number 4. In order for the attachment to be carried out, the defendant's property must be somewhere within the Republic of South Africa. Note that Section 21, subsection 3 of the Superior Courts Act deals only with attachment of property to confirmed jurisdiction. This does not mean that attachment to found jurisdiction is no longer part of our law. Rather, regard must be had to the principles of the common law in respect of attachment to found jurisdiction. In conclusion, note that magistrates' courts are also entitled to order the attachment of property to found or confirmed jurisdiction against persons who do not reside in the Republic and in respect of actions within their jurisdiction, where the claim or the value of the matter in dispute amounts to at least 2,500 Rand exclusive of costs. 3.5.1b. Consent to jurisdiction. As pointed out in the introduction of this section dealing with the High Court jurisdiction, consent to jurisdiction may be regarded as a fundamental common law principle of jurisdiction. Although consent to jurisdiction may be of relevance to cases other than those in which the defendant is a foreign peregrinus, it is in relation to this last mentioned category of cases that the principle finds much of its practical application. It is for this reason that we deal with the principle of consent to jurisdiction in conjunction with the principles relating to claims against foreign peregrini. As discussed in the previous section, when dealing with a claim sounding in money against a foreign peregrinus, an attachment ad confirmandum or ad fundamendum jurisdictionem is usually required. The principle of consent to jurisdiction is of relevance in the cases because should the foreign peregrinus defendant consent to jurisdiction, such consent renders an attachment impermissible. What happens, however, if the foreign peregrinous defendant consents to jurisdiction after the order of attachment has been granted? The answer appears to be that if the consents to jurisdiction after the order of attachment has been granted, but before it has been put into effect, then he is entitled to a discharge of the order. If, however, he consents to jurisdiction only after the writ of attachment has been executed, then he is not entitled to a discharge of the order. Let us conclude with a few brief comments on the limitations of the concept of consent to jurisdiction. It is important to note that consent to jurisdiction simply acts to extend jurisdiction which is already in existence. In other words, consent by the parties cannot confer jurisdiction on a court when there is no other link, other than the consent between the court, the parties, and the claim. Despite its limitations, however, it is interesting to note that there are legal scholars who feel that the concept of consent to jurisdiction is capable of a wider legal interpretation. For example, Ellison Khan feels that there is no good reason why, if the plaintiff is an insular of the court, consent to jurisdiction by a local peregrinous defendant should not, in the absence of any other ground of jurisdiction, be sufficient to establish jurisdiction. In American flag, it was decided that where an insular sues a peregrine in the Republic as a whole, a foreign peregrine, for a judgment sounding in money, prior submission by the peregrine to the jurisdiction of the court suffices. Attachment is neither necessary nor permissible. The judgment in American flag is confined to foreign peregrines, specifically excluding local peregrines, those resident or domiciled in the area of some other division of the High Court of South Africa. Surely there can be no objection to a local peregrine submitting to jurisdiction. It would be against economic policy for a jurisdiction against a local peregrine to be more confined than that against a foreign peregrine. Okay. 3.5.2 Claims for divorce and associated relief. The most important point to note in relation to claims for divorce and associated relief is that this area of law is regulated by statute. In terms of the Divorce Act, a divorce action is defined as an action by which a decree of divorce or other relief in connection therewith is applied for and includes a. An application pendente lite for an interdict or for the interim custody of or access to a child of the marriage concerned or for the payment of maintenance, or b. An application for a contribution towards the costs of such action or to institute such action or make such application in forma pauperis or for the substituted service of process in or the edical citation of a party to such action or such application. Although the Divorce Act does not derogate from the common law jurisdiction of the courts in respect of such claims, the provisions of the Act offer important additional grounds of jurisdiction. The most important subsection of the Divorce Act relating to jurisdiction reads as follows. Subsection 1. A court shall have jurisdiction in a divorce action if the parties are, or either of the parties is, a. domiciled in the area of jurisdiction of the court on the date on which the action is instituted, or b. ordinarily resident in the area of jurisdiction of the court on the said date and have or has been ordinarily resident in the Republic for a period of not less than 1 year immediately prior to that date. Jurisdiction is not restricted to the court within whose area the defendant spouse is domiciled or resides. The domicile and residence of the plaintiff also becomes relevant for jurisdictional purposes, since the subsection speaks of either of the parties. In other words, if a wife is suing her husband for divorce, she may do so where she is domiciled, or where she is ordinarily resident, provided that she has been ordinarily resident in South Africa for at least a year immediately before this date. This is a radical departure from the common law principle of acta sequitur forum rei. Jurisdiction in respect of many divorce actions that you encounter in practice will be covered by Section 2, subsection 1a of the Divorce Act set out above. The subsection refers to the domicile of either of the parties to the divorce action. Every person who is over 18 years old, apart from those who lack the mental capacity to make a rational choice, is entitled to inquire a domicile of choice. This applies regardless of a person's sex or marital status and means that married women are no longer obliged by law to adopt the domicile of their husbands. Let us assume, for example, that a wife leaves her abusive husband who lives in Cape Town and moves to Durban, where she obtains employment. Provided that she intends to settle in Durban for an indefinite period, Durban will be her domicile of choice. Therefore, she is entitled to bring an action for divorce in the KwaZulu-Natal Local Division, Durban, or the Regional Magistrates Court, Durban, although she could, of course, choose to institute action in the KwaZulu-Natal Division, Pietermaritzburg, which exercises concurrent jurisdiction with the KwaZulu-Natal Local Division, Durban, or in the Western Cape Division, Cape Town, within whose area of jurisdiction her husband is domiciled. Section 2, subsection 1b of the Divorce Act set out above is able to deal with those clauses where Section 2, subsection 1a is not applicable. Let us take the same example as that used above, but assume that the wife has moved to Durban on a fixed 1-year contract and intends to move back to Cape Town as soon as the contract terminates. In this case, it cannot be said that she is domiciled in Durban. She is, however, ordinarily resident in Durban and has presumably been ordinarily resident in South Africa for at least 1 year immediately before she moved to Durban. Therefore, she is entitled, in terms of Section 2, subsection 1b of the Divorce Act, to institute action in the KwaZulu-Natal Local Division, Durban, or the Regional Magistrates Court, Durban. Note that the provisions of Section 2, subsection 2 of the Divorce Act, which are as follows. A court which has jurisdiction in terms of subsection 1, as set out above, shall also have jurisdiction in respect of a claim in reconvention or a counter-application in the divorce action concerned. Note also that jurisdiction in a divorce matter may not be conferred on a court by consent or submission. 3.5.3 Claims for interdicts. Interdicts are dealt with in detail later in this book. For the moment, let us just say that an interdict is an order by the court that a person either perform some action, a mandatory interdict, or refrain from performing some action, a prohibitory interdict. A good example of a prohibitory interdict would be where you want the court to order your neighbor to stop digging a large hole next to your common boundary fence, which is threatening to undermine your house. When deciding whether or not a particular High Court division has jurisdiction to hear particular interdict proceedings, 2 questions should be asked. First, is the respondent an incula or a peregrinus of the court concerned? Secondly, is the act you are trying to force the respondent to perform or refrain from performing linked to the territorial area of jurisdiction of the court concerned? 3 different possibilities then arise in relation to jurisdiction. First, respondent is an incula, and the act is either within or outside the area of jurisdiction. In such cases, the court has jurisdiction to grant an interdict, whether mandatory or prohibitory in personam against the incula, whether the act in question is to be performed or restrained within or outside the area of jurisdiction of the court. Secondly, respondent is a peregrinus and act within the area of jurisdiction. Because the court has power to compel or prohibit acts within its area of jurisdiction, it has jurisdiction to grant either a mandatory or prohibitory interdict. It does not matter if the respondent is a citizen of Outer Mongolia, the court may still compel him to perform or desist from performing an act within the jurisdiction of the court. And lastly, respondent is a peregrinus and an act outside the area of jurisdiction. Because the court has no power over either the respondent or the act, it has no jurisdiction to grant either a mandatory or prohibitory interdict. This applies whether the respondent is a local or a foreign peregrinus. 3.5.4 Single claims involving two or more jurisdictions. Occasionally, you may be confronted with a situation in which you are dealing with what you believe to be a single case, but you find that two or more courts exercise jurisdiction in respect of different parts of this single case. Since it does not make sense for two or more courts to deal with a single matter, you may wish to turn to the ground of jurisdiction known as the ration causae continentiae, which may allow one of the courts involved to exercise jurisdiction in respect of the whole matter. Harms provides the following useful summary. More than one claim may be joined in one process before a court against different persons or in respect of different things in different jurisdictional areas, if together they really constitute one case. An indivisible obligation in respect of an indivisible thing which is situated in two different jurisdictional areas may be enforced in any of the areas concerned. The causae continentia doctrine was extended by the Supreme Court of Appeal in the Nguza judgment. Application was brought on behalf of a class of persons consisting of tens of thousands of recipients of social disability grants, whose grants had been terminated unilaterally and without notice by the Eastern Cape provincial authorities. Not all the persons of this class resided within the jurisdictional area of the High Court before the application was brought, that is, the Eastern Cape Division of the High Court. In holding that the jurisdiction of the Eastern Cape Division did indeed extend to these non-residents, Cameron invoked the causae continentia doctrine by stating as follows. In Roberts Construction versus Wilcox Bros Proprietary Limited, this court held, applying the common law doctrine of cohesion to a cause of action continentiae causae, that where one court has jurisdiction over a part of a cause, considerations of convenience, justice, and good sense justify its exercising jurisdiction over the whole cause. The partial location of the object of a contractual performance, a bridge between two provinces within the jurisdiction of one court, therefore gave that court jurisdiction over the whole cause of action. The court expressly left open the further development and application of the doctrine of cohesion of causes. The present seems to me a matter amply justifying its further evolution. The Eastern Cape Division has jurisdiction over the original applicants and over members of the class entitled to payment of their pensions within its domain. That, in my view, is sufficient to give it jurisdiction over the whole class, who, subject to satisfactory opt-out procedures, will accordingly be bound by this judgment. 3.6 Inherent jurisdiction. Inherent jurisdiction is a discretionary power possessed by our superior courts. Writing in the period before the advent of South Africa's present constitutional dispensation, it was described by one South African academic as follows. The inherent jurisdiction of the Supreme Court, that is, the High Court, may be described as the unwritten power without which the court is unable to function with justice and good reason. The power was originally derived from English law, and the following useful definition of the concept was put forward in a Canadian case. The reserve or fund of powers, a residual source of powers, which the court may draw upon as necessary whenever it is just or equitable to do so, and in particular to ensure the observance of the due process of law, to prevent improper vexation or oppression, to do justice between parties, and to secure a fair trial between them. Traditionally, courts make use of their inherent jurisdiction to avoid a procedural injustice from occurring, either by overriding the rules of courts or providing some procedural remedy where none existed. Despite a perception that inherent jurisdiction was the power of superior courts to do whatever they wished, provided that it was not prohibited by law, Tates pointed out that the court does not enjoy the inherent power to change or otherwise create substantive rights which previously were not part of our law. Although inherent jurisdiction was usually regarded as a procedural power, it was not entirely procedural in nature. The power was discretionary in nature, and a court was not obliged to use its inherent jurisdiction in any particular situation. Asking the court to exercise its inherent jurisdiction was therefore unlike asking it to enforce a right. Let us look at some practical examples in which superior courts have traditionally exercised their inherent jurisdiction. Number 1. To regulate its proceedings and prevent an abuse of its process. Superior courts are not bound by their rules and may create their own procedure. The rules are there for the courts and not the other way around. If the rules lead to injustice in a particular situation, the court need not follow them. One example of this is the fact that most divisions of the High Court insist that the defendant in a divorce matter be served personally with the divorce summons. This is despite the fact that there is no rule of court which requires this. Tates provides the following examples of situations in which the court has exercised its inherent jurisdiction in regard to litigation. To order further particulars, to allow the registrar to act as a stakeholder pending the settlement of a dispute, to provide a superannuated provisional sentence summons, to rescind a default judgment not falling under the rules of court, to permit joinder of defendants, to order a party to produce documents for inspection not referred to in his discovery affidavit, and also to produce for inspection items of machinery, to condone the late filing and non-compliance with rules of court where principles of justice and fair play demand an order to avoid hardship to a party, to control its own proceedings by refusing to accept unnecessarily prolix affidavits in Rule 43 proceedings, to grant a peregrinous relief to sue in forma pauperis. Number 2. To protect its dignity, repute, and authority, and compel observance of its lawful orders. Section 108 of the Magistrates Courts Act provides for the punishment of those found guilty of contempt of court. There is no equivalent provision in the Superior Courts Act, but the High Court is able to punish such offenders by making use of its inherent jurisdiction. Tates points out that the distinction between criminal and civil contempt of court is relevant to this section. More particularly, the willful violation of its dignity, repute, and authority amounts to criminal contempt, while civil contempt may be seen as the intention and/or mala fide disregard or refusal by a party to comply with its lawful order. Number 3. To control and supervise its officers. Officers of the court include inter alia attorneys, advocates, prosecutors, deputy sheriffs, the master, the registrar, and the clerks of the various courts. Magistrates and judges are not officers of the court as they comprise the court itself. Despite the fact that many situations pertaining to officers are provided for in legislation, the court may still resort to inherent jurisdiction where a gap exists. In the past, courts have used their inherent jurisdiction as follows. First, to regulate the conduct of attorneys and prescribe general rules of practice. Second, to condone non-compliance with rules relating to the procedures for the admission of attorneys. Third, to order an attorney to show cause why he should not be struck off the roll for misconduct. 4. To strike an advocate from the roll of advocates for misconduct. And 5. To protect practitioners by punishing persons who unlawfully hold themselves out to be attorneys. Number 4. To restrain irregularities in the proceedings of inferior courts. Although Section 21, subsection 1b of the Superior Courts Act gives the High Court the power to review the proceedings of magistrates' courts within its area of jurisdiction. Tate's notes as follows. Relief by the court in terms of its inherent powers to restrain irregularities remains of the greatest importance, as an examination of the cases shows serious limitations in the exercise by the courts of the statutory forms of review. Number 5. To restrain irregularities in the proceedings of administrative and like authorities. Historically, the courts relied on their inherent jurisdiction to review irregularities in the proceedings of administrative authorities. In Johannesburg Consolidated Investment Co. versus Johannesburg Town Council, hereinafter referred to as the JCI case, Chief Justice Innes found that the court enjoyed the power of judicial review of administrative action by reason of the inherent jurisdiction it enjoyed as a superior court. In this much quoted judgment of the JCI case, the learned Chief Justice went further than establishing the judicial power of testing the validity of administrative action. He found that through its inherent powers, the court had created a remedy which enabled it not only to review the offending decision, but also to grant consequential relief to an aggrieved party by either setting aside or otherwise correcting such decision. Today, the court's inherent power of judicial review has been entrenched in Section 33 of the Constitution, the right to administrative justice, read with the Promotion of Administrative Justice Act 3 of 2000. Number 6. To create or modify remedies. Note at the outset that the courts may not use inherent jurisdiction to create a right. A right either exists or it does not exist. If it does, the courts will imply a remedy, even if there is no apparent remedy, in terms of the common law principle of ubi jus ubi remedium. That is, where there is a right, there is a remedy. Therefore, there is no need to appeal to a court's inherent jurisdiction to secure the enforcement of a right. For example, the granting of an interdict is not an exercise of the court's inherent jurisdiction, since in order to be granted an interdict, you must show that you possess a right in the first place. Inherent jurisdiction enters the picture when you ask the court to create a remedy in the absence of a right. The courts use their inherent jurisdiction to create a remedy in those situations in which no legal right to a remedy exists, but an injustice, usually of a procedural nature, will occur if a suitable remedy is not granted. The so-called Anton Piller order is a good illustration of the use of inherent jurisdiction to create a remedy in the absence of a right. Such an order usually allows an applicant to search the premises of a respondent without notice in order to seize and preserve evidence that the applicant will require in a subsequent trial. Such an order will only be granted if the normal procedural methods of procuring evidence will not avail the plaintiff, and an injustice will occur if the order is not granted. Note that no one has the right to search another person's premises and seize items without that person even knowing about it. The Anton Piller order is therefore a remedy which is granted by the court, in the absence of a right, in order to prevent procedural injustice. Other examples of situations in which the court has used its inherent jurisdiction to create or modify remedies are cases that deal with the obtaining of blood samples for proof of paternity. No one has the right to take blood samples from someone else, but in certain cases the courts have been prepared to order that this be done in order to prevent an injustice. In other words, the courts have used their inherent jurisdiction to grant a procedural remedy in the absence of an existing right. Furthermore, the courts have relied on their inherent jurisdiction to create a remedy for plaintiffs in bringing class actions. In the post-apartheid period, the traditional approach to inherent jurisdiction, discussed briefly above, must be read in light of the provisions of the South African Constitution, in particular Section 173, which provides that The Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa each has the inherent power to protect and regulate their own process, and to develop the common law, taking into account the interests of justice. This section builds upon the previous inherent powers of the superior courts. It has enabled our superior courts during the post-apartheid period to develop a range of innovative new orders which promote the interests of justice. It has been held that this section is an important tool enabling the superior courts to ensure their own independence and impartiality, and to regulate and protect their own processes. Section 173 must be read with Section 39, subsection 2 of the Constitution, which requires a court, when interpreting any legislation and when developing the common law or customary law, to promote the spirit, purports, and objects of the Bill of Rights. Finally, note that, although Section 173 of the Constitution clearly broadened the scope of judicial activism during the post-apartheid period, due regard should be paid to the following note of caution expressed by the learned authors of Harpstein and van Vinsen, The Civil Practice of the High Courts and the Supreme Court of Appeal of South Africa, 5th edition. In Krijgkor Pensioenfonds versus Smith, 1993, the Appellate Division held that only in exceptional cases will the court exercise its inherent jurisdiction to follow procedures not regulated by the ordinary law of procedure. It will do so only when the requirements of justice demand a deviation from the ordinary rules of procedure, and, even when a deviation may be necessary, the court will always attempt to deviate as little as possible from established procedure. This dictum should be borne in mind even though it predates the enactment of Section 173 of the Constitution.